Oh, okay. I'll check 6 as well. Okay, guys. So we're streaming now at the moment on YouTube. So hi to anybody there that is going through and watching things in the chat. Topic 6 content. I'm just clicking and waiting for that to load up. No, it's there as well. It should be there. Topic 6 should be there. Just do a refresh on your thing there. Seems to be there. Okay. As well as streaming, I'm also going to turn the recording on because we're going to put on the screen the the material for this week, and there's quite a lot. So I'm going to go through and talk through. And look, I appreciate again, guys, that that English is not the first language for a lot of people in this class, and I'm going to be using some technical language. It's very likely that you guys are probably going to have to watch this more than once. It wouldn't surprise me. And I said apologize for this particular week, week 5 with vitiating factors, and week 6, which is discharges and remedies. It is both a blessing and a curse. The blessing is it is the most useful material probably for the entire subject. This is the real nitty gritty of contract law. Ways to get out of contracts and when contracts fall apart, what's going to happen from both a personal and a professional view. This is the stuff that a lot of people usually want to go through and know. And so this particular part, or what's called vitiating factors, I've got my little wheel that I've got here, and the wheel is I guess the 5 components that we go through and talk about that. This is the 3rd out of 5, and it's the vitiating factors are really to do with defects in consent or true consent as part of this aspect of contract law. Now, remember in the first week we talked about when we were talking about formation, and we did talk about this idea that the people had to have a mutual understanding of the subject matters, and this is true. What we do find though is that we can start with this idea that there is a validly formed contract. All of the elements are present. Nonetheless, there's something wrong with it. But it's not strictly speaking a defect in formation. There is a contract, but people can go up to the court and ask for some other remedy. And this is it's a really important distinction between the week 5 material and the week 6 material. Vitiating factors are where we start with, at least on the face of it, a valid contract, but there's some defect in how it's been put together that really undermines the true consent of the parties. And it's really this idea of true consent that means that the party who can go through and prove one of these defects can get some sort of result. We use the phrase remedy in law. It's a result of some sort. Some of the results may be to have the contract undone in entirety, but often it's not. Often you're going to get something else. Sometimes it's just a right to undo the contract that lasts for a finite length of time, for example. Sometimes it might lead to get some sort of money payment as a result of this defect. But so this area that we broadly call these actions that you can take them to court, we call these vitiating factors. Okay, and a couple of things to note about this is that these are brought to the court as independent actions. So when we go to the court, we can actually go to court and make an argument that we deserve some form of remedy, or even more importantly, that the court must give us this remedy. We demand it by right because we've satisfied all of the elements. Not the elements of a contract. We're going to leave that aside and assume that that's formed. We are going to try and satisfy, in this case, the elements of misrepresentation, a common law. Or we are going to try and satisfy the elements of mistake, one of the different types of mistake, or duress, or undue influence, unconscionable transactions, or illegality. Okay, we are going to the court to try and get something. I've always loved teaching the accounting students and the material students because we're a little bit more conscious of when going through and learning this stuff, we translate it back to the bottom line. When going through to court, going to your lawyer seeking legal advice, we want to go because we've got in the back of our mind some notion that we are going to actually be able to translate this back into dollars. Sometimes the dollars that we want to do is to save to have contracts undone. Okay, and so really the key thing is consent. Consent comes up in a variety of different areas of law, but when we're looking at vitiating factors, this idea that the consent to enter into what looks like an otherwise fully formed and valid contract has somehow been undermined, and that as a result gives us some form of remedy. Okay, so I'll put that up there, and again, apologies because I have to go through and mix and match these slides. So we're going to start with the first one of these, which is again a bit of a broad church. The slide that I had earlier to do with listing the various vitiating factors. When I say we're going to go through and learn these 6 areas, I must make really clear from the outset, some of these come up much more often than others. And so of these things, the one that you're most likely to be trotting off to court to do is misrepresentation. It occurs much more likely than the other factors, at least the other factors where you can get some sort of result. Some of these are much narrower, the other ones. And look, that comes down to, if we think about it, it's the nature of business. People are scarce with the truth when they're entering into contracts a lot more often than, for example, both parties being mistaken, or one party threatening to break the other one's kneecaps, or one person having some special relationship that needs overturning. That just happens a lot more often. Although that said, I have just noticed on this that the first one we are going to talk about is going to be mistake rather than misrepresentation. So just bear with me that this area of law, we do have to go through and teach you guys, and I actually have something of a blessing here, and Stephen, whether he appreciates this or not, is that a lot of these areas have actually flowed from the Accounting Society saying, in order to teach people that want to become accountants things, they need to know all of these things. And so we've just said, okay, here we go, we're going to teach you all of these things. And so this won't come up that much. At least the first 2 categories won't come up much in your professional and business career, but you need to sort of have them on the back of your head, back of your mind. Okay, and so this idea of mistake, it's a broad category to describe 3 different distinct causes of action. And so the key thing to note is that people can be mistaken when they get into contracts. And look, at the end of the day, people are mistaken all the time when they enter into contracts. Usually, though, it's not both parties being mistaken. Usually, it's just one party being mistaken, which I'll come to a little later. But mistake, and this is the real technical definition, requires there to be something very serious, and something that serious mistake must go very much to the heart of the party's contractual obligations and or the subject matter. And so I'll talk about a couple of these, because we will coming back, and you find with a lot of these cases, because they don't come up very much in the courts, and particularly the higher courts, often what you'll find is that the judges in these cases, in this case McRae is a high court case, they talk about all of the different types of mistake, and then often pick up and say, well, in this situation this one's not going to apply and this one's not going to apply for this. So we'll start with McRae and the Commonwealth. Commonwealth Disposals Commission, I should say. So the Commonwealth Disposals Commission was a body that was set up by the Commonwealth, and it had a job of trying to get some money from private individuals who were interested in doing salvage for boats that had been sunk during the Second World War. Okay, and so that was their job. And so if you think about it, if you had a very large vessel that sunk, this for salvage teams, and they're rustic individuals who go through on the high seas to try and send divers down and try and withdraw things from it. Okay, thanks, Stephen. Cheers. They're a difficult mob, these sort of salvage teams, and so the Commonwealth Disposals Commission was established so that they would be able to go. Oh no, Hina's gone, and do these salvages. And so In the Coral Sea, for example, if you guys know much about the history of Townsville, Coral Sea was a very, very important naval battle between the Japanese and the Americans, supported by the Australian, the RAAF, based out of Townsville. And so, if you guys do get a chance, by the way, go up to what we call Genzine Barracks. So, the rock pool at the end of the Strand, the north end of the Strand, you can walk up the hill and it shows a little outline of the Battle of the Coral Sea. And so that during the Battle of Coral Sea, a whole bunch of big boats were sunk. And so McRae had a salvage business, and he paid some money to the Commonwealth to go and salvage money from an oil tanker, refueling tanker that had sunk on a reef in the Coral Sea. Okay, seems pretty simple. Well, would have been simple, other than the reef didn't exist and the boat didn't exist. So, as you could imagine, McRae's wandering around going through all of these charts that the Commonwealth Disposal Commission have given them, and then has come back and gone, what the heck? What's happened here? And so there the courts did go through and they talked about a variety of the three different types of mistake as part and parcel of that. And there they had said in this particular set of circumstances that it probably wasn't going to apply in that case. And that because essentially, as part and parcel of it, the Commonwealth Disposals Commission had actually guaranteed that there would be, as part of that, it had actually formed a term of the contract. So McRae got up in that one. Taylor and Johnson is a case that involves unilateral mistake, where one party was the contract was mistaken. And actually, I might just talk about that when we come to unilateral mistake, because these, I believe they're on the next slide anyway. Because these, when parties are mistaken, they can do it in one of three different ways. Either one side's mistaken, we call that unilateral mistake, or the two parties are mistaken, and this is the argument that the Commonwealth Disposals Commission had run. Two parties are mistaken about the same thing. About the same thing. And look, the court in McRae did jump up and say that, look, hey, common mistake can exist. It is a feature of our law, and it happens where both parties to a contract are mistaken about the same thing. In other words, they share the same mistake. It is common between them. And so again, the CDC in the McRae and the CDC case, they had said, "Oh, well, this is just a common mistake," and the court said, "No." The existence of the reef, while it was very, very, very important to the contract, clearly, and both parties were mistaken about it, you'd actually guaranteed that it existed. And so as a result, it wasn't going to be a common mistake. It's just going to be straight up breach of contract. All right. But in another case, though, when we look at, which is, have I got it on there? No, I forgot it on the first slide. A case called Great Peace Shipping. Oh, Vina, question. Yes.
But actually, I have a doubt. When both the parties make mistake,
Yep.
so it will lead through the breach of the contract.
No. They're two quite different and distinct things. Okay. If there is a breach, there's no mistake. It cannot be a mistake. They are like oil and water. They cannot exist as part of the same situation. They can't exist in the same situation because if one side has promised that something is true, in other words, they've guaranteed the particular promise at the time of formation, all right, the fact that both sides are mistaking is just tough luck. One side has promised that this thing existed, and that's what happened in McRae and the Commonwealth. As a result, it's not common mistake, it's just breach of contract. Both sides are mistaken, sure, but it doesn't matter. The contract is not going to be voided as a result if one side has agreed. All right, it has to be something that both sides, when they formed the contract, actually went at the time of formation and were equally mistaken about. And so in Taylor and Caldwell, for example, the thing that they were mistaken about was the existence of the subject matter. Taylor and Caldwell involved the hire of a big opera house for a very, very large function. Now, unbeknownst to the parties, at some stage they formed this particular contract, and around about when this particular contract was formed, the hall burnt down. Okay, and what the judges there had said that, look, if the hall had burnt down before the contract is formed, that's going to be common mistake. If both parties are equally mistaken about the subject matter and it happens before the time of formation, and we're both equally mistaken, and no side guarantees the existence of this particular thing, in this case, the subject matter, both parties are mistaken and it happened before the time of formation, common mistake will apply. And if common mistake applies, the contract is void. There was no contract. Okay, and this can matter in terms of remedies the parties seek later on. Okay, because it means that there's some sides that may or may not be liable, and if goods have passed, those goods the title can't pass because there is no contract. You can use certain doctrines of restitution to get your money back. Now, it's different, however, if in this case Taylor and Caldwell, the hall burnt down after formation. And again, if neither party thought about this, that we didn't put this into the contract at all, the existence, one party guaranteeing that it will exist or not, a different set of rules and principles apply. It's a thing called the doctrine of frustration that can use to discharge the contract, and that is stuff for next week. We'll talk about the doctrine of frustration. So you just need to note, because I might actually be known to put that in your semester test. If the subject matter, unbeknownst to the party, is destroyed before the time of formation of the contract, it's going to be a common mistake. If it's afterwards, the contract does actually exist. And that's just, it can be sometimes frustrated. But the important thing for both of these things is that only happens if one side doesn't guarantee it. In other words, it's not a term of the contract. Because if I'm guaranteeing there will be a hall as part of this Taylor and Caldwell situation, or if I am guaranteeing there is a reef with an oil tanker on it, if I'm making that's a term, I'm just going to be in breach. I'm just going to lose. Does that make sense to you guys? Nathan?
Can you please, what do you call, can you describe it please again?
Yeah, sure thing.
Yeah,
Um,
kind of like,
oh, it's really hard. It's hard. It's messy. It can be a little bit all over the show. Okay. If a contract is formed, all right, and there is something that goes right to the heart of that contract, so that the subject, so for example here, having this massive event in this music hall, all right, the existence of the music hall goes absolutely to the heart of the contract. In the case of McRae and the Commonwealth Disposals Commission, the existence of a reef with a boat with oil in it, a sunken vessel, that goes right to the heart of the contract. It was a fundamental thing that the parties, when they came together, were looking at, and they would never have come together if that thing didn't exist. Okay, they would never have had this meeting of minds. But importantly, neither side guaranteed that it would exist. Okay, that's a really important consideration. If we decide to have a contract that we will, for example, we will have a festival. So if we had a contract, was it Nathan I was talking to, I think? If Nathan and I, if we had a contract that we were going to have a big festival, and it was going to be on the Strand or the Strand Park in Townsville. Now, you guys, appreciate, are we allowed to have those festivals now? No, not allowed to have those festivals at all. All right. If that happened after we formed the contract might be frustrated. That's the material we'll do next week. If it happened before we did the contract, then common mistake can apply. So we are both mistaken about the fact that we could have this particular festival in this particular piece of land. But the key thing here is when we're having this contract, neither of us promised to the other that that particular piece of land was able to be used. All right, and so that when the coronavirus comes through, it's been outside the scope of what everybody thought about. A lot of people didn't guarantee that they would have been able to have gatherings of more than two people at this stage. It's something that neither side would have foreseen, and neither side did foresee, and that's how parties can be mistaken in that. This one's a little bit hard. And it is particularly hard because when you're trying to work out whether things go to the heart of the contract, it can be a little bit difficult because this Leaf and International Galleries case involved a painting by a famous English artist called John Constable, all right? And it was a painting of the Salisbury Cathedral sold at an auction house, all right, called International Galleries. And Mr. Leaf bought one of these paintings, and then he found out that the thing that was signed Constable at the bottom wasn't John Constable, it was Bob Constable, some other person whose name was also Constable. Okay, so he thought he was paying a lot of money for a painting by this famous artist, John Constable. But when he got it, it turns out it was painted by somebody called Constable, but it wasn't the famous person. It was some other person called Constable who was much less famous. It was worth a lot less. Now, unfortunately, Lord Denning in this case said that, look, here, both parties are mistaken. The gallery and Mr. Leaf both thought it was John Constable. Turns out they were wrong, right? But Lord Denning said in that situation, it actually didn't go to the heart of the contract. Why? Because Mr. Leaf still had a painting, a nice painting of the Salisbury Cathedral, painted by somebody called Constable. So that case is sometimes really hard to reconcile with some of the other cases on mistake as a result. Some people have looked at it. Some people think that Lord Denning's wrong. Some people think that case ought to have been decided differently. Hina, question?
We call it a common mistake only when both of the parties have been the mistake, or it's only from one side?
Common mistake requires both sides to be mistaken. I'll get
In this case, in the painting, even the company did not do it?
absolute. The gallery house and Mr. Leaf were both wrong, but Lord Denning said that, look, at the end of the day, yeah, you are mistaken, but it didn't go to the heart of the contract. It wasn't fundamental to the contract that it was actually by the real famous painter, John Constable. At the end of the day, he got a painting by some guy called Constable. That was what things there. I said it might not be the best judge decision. So I'm gonna just quickly talk about something because this is part of your assessment, or it can be if you choose this question. A case called Great Peace Shipping and I can't pronounce it. It's a Greek company, Savalaris. We call this the Great Peace Shipping case. Okay, it's an English case, right? And there they said, in that case, it involved a boat that was. Oh, George, yes, George. Yep, no. Okay. It involved a rescue off the Cape, I think about 500 nautical miles off the coast of Tanzania or South Africa, around there somewhere. And when you guys are aware, when boats are in trouble, the law of the sea says nearby boats are obliged to go and help them. There's a long thing, but they don't do it for free. It's very expensive. Shipping is very, very, very expensive. It's a big money business. And so what happened was and this is in the mid-90s, the boat was in trouble, the Great Peace, and so a nearby boat turns out was 13 nautical miles away. So they were called up. They both got on their sat phones. They called Singapore. They formed a contract, and this boat went to help the Great Peace. But it turns out it wasn't 13. It was 413. As you could imagine, this salvage turned from being a day or two, which a couple of £100,000, to being massive, 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 massive thing. So there, both parties were mistaken. Okay, there was a serious mistaken belief, and the court said yes, common mistake applies. However, what they said was that, and this overturned a lot of previous cases that I haven't gone through here. A case called Solé and Butcher, also by Lord Denning from a long time ago, and that said that, look, in situations where Both sides are mistaken. Equity can intervene to prevent injustice. And in Great Peace, the court said, no. No, equity is not to intervene. There is no contract. Full stop. There was no contract. If common mistake is found, common law, the contract is void. You don't make up principles on the fly to try and bring some sort of justice to the situation. Sure, there are some other areas of law that you can use. You can use, try to use negligence, try to use other things, try to use restitution where money's been paid. But fundamentally, you don't use equity to try and resolve this problem. Now, unfortunately, in Australia, in Queensland, the Queensland Court of Appeal, and this Australia States Proprietary Limited and Cairns City Council, they have followed Great Peace. So they said Great Peace is good law. Equity should not intervene to try and prevent some injustice. You can use other areas of law, but by default, if there is common mistake, the loss falls where it lies. Okay, if both parties are mistaken, there is no contract. The loss falls where it lies, and so that you can use things. If you've given somebody your goods, they're still your goods. You can go and grab them back. If you've paid money, that money you can use the doctrine of restitution to get that money back. But you're not using equity's jurisdiction under common mistakes. So it overturned a rule from a case called Solly and Butcher, and the Queensland Court of Appeal followed Great Peace. It hasn't been followed anywhere else in Australia. So the law in this area is actually a little bit difficult, because in theory in Queensland we have to follow this. If there's a common mistake into a contract, the loss will fall where it lies. You can't use equity to try and resolve that injustice. You can use other areas of law to try and fix it, but not the rule in Solly and Butcher. Whereas in theory, everywhere else in Australia is still using the old rules that where equity can resolve an injustice. That's a developing area of law. When I say developing, that was 2005. It's 15 years ago. Won't develop for a while because these cases don't come up much into the superior courts. Okay, a common mistake does not come up very much because both parties are mistaken about something. Again, it's a very, very rare thing. But what is even more rare, exceedingly rare, is mutual mistake. So mutual mistake occurs where each of the parties is correct about the subject, but there's two subjects. You're like, what the heck does that mean? What it means, and again, this is a little bit difficult to go through and think about. If Hina says to me, or I say to Hina, I've been driving past her house for a few days and she's got this lovely blue Mitsubishi Evolution Lancer turbocharged thing, and I say, hey, Hina, I'd like to buy your blue Mitsubishi for $5,000. And she goes, oh, fantastic. That sounds like a great idea. Sure, I'll happily take $5,000. Okay? And when I rock up to the house, she thinks that I was referring to the blue Mitsubishi Magna that she has parked behind her house that she drives to and from work. I, though, was thinking about the blue Mitsubishi Lancer that she had in the front of her house, the really cool looking house. All right? So if you think about it, this is a pretty rare situation where this would come up. If neither of us is actually mistaken in regards to this contract, but there are two subjects. As you can imagine, this is a real corner case scenario, which is why the case for this, Raffles and Witchell House, is a real corner case piece of case law. It actually involved a contract for a shipload of cotton to ship from, I think it was Mumbai, to Britain, coming on a boat, a shipload of cotton coming from Mumbai in a boat called the Peerless, Pererless. Okay, so shipload of cotton coming from Mumbai on a boat called the Peerless. It turns out there were two boats with the same name that happened to be shipping cotton from Mumbai that year. One was going in July, one was going in December. Both parties had signed a contract, but they were referring to two different boats, two different subjects. They were what we say at cross purposes. So they're negotiating a price, but they're talking about two different things. Look, it's a very rare corner case, but it's part of the things you need to know. It can I mean, it might come up in your life, probably won't. But what will come up in your life much, 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 much more often. It happens only in India. Nice. What will come up much more often in your life is this next one: unilateral mistake. Unilateral mistake occurs where one side to the contract is mistaken. Oh, how was it solved? There's no contract. I'll talk about the remedies at the end, but for common mistake, in Queensland at least, and for mutual mistake, the contract is void. There is no contract. The contract is void ab initio. You can use a variety of other areas of law to get your stuff back. We can use a thing called tort. If you go and you call them up and say, there was no contract, we would like our money back, and you use restitution as a doctrine to go and ask for your money back. You can use, if they're refusing to give your goods back, you can use a tort called detenue. We'll talk about them in week 8. But other areas of law are used to resolve it, not contract law. That's the key thing to note here. It's not that this. Okay, I'm getting a little message saying that my video quality is low. Okay, with this area of law though, this unilateral mistake, this comes up all the time. It's very, very, very common that one party to contract's mistaken, and for the sale of goods, the default rule of caveat emptor is going to apply. What does that mean? Buyer beware. When you are buying goods, be very careful that you check the goods and you know what they are. You know the underlying content and subject matter behind them, because in the default rule is in contract law. Oh, Nathan, yes.
Sorry, I keep disturbing. What's the
That's fine.
difference between mutual mistake and common mistake? Again, it's like
Okay, no problem. Common mistake is where the parties share the same mistake about something fundamental to the contract. So if we go back to the oil tanker on a reef, both sides, or at least they tried to argue, both sides didn't know that there was no reef and there was no tanker. That's something fundamental to the contract. All right?
that means that goes to base, like you said,
Heart of the agreement. It has to go right to the heart of the contract. All right? It can't just be something, a quality of the contract. For example, with Leaf and International Galleries, where it's just a painting by some person called Constable. Yeah, sure. Both sides thought it was the famous English painter John Constable. It turns out it was by Bob Constable, some other less known artist. At the end of the day, that wasn't fundamental. At least that's what Lord Denning said. All right? That is where both parties share the same mistake. That's why we say it's common mistake. Now, mutual mistake is where the parties are at cross purposes. There are two subjects. So I'm not mistaken about what I'm talking about. I thought that Hina and I were contracting to sell the blue Mitsubishi at the front of our house. She thought it was selling the blue Mitsubishi at the back of our house. We're like ships in the night. We're not having a true meeting of minds. And in both situations, there's no contract. Okay, if money is passed, you can use some areas of law to get it back. If goods have passed, you can use some other areas of law to get those goods back.
that means both of them having like two different purposes.
Yeah, we're at cross purposes. It means that I'm not mistaken and she's not mistaken, but that there's two subjects. Common mistake is where there's one subject, we're both mistaken about something fundamental about that subject. Its existence, for example, like that with that reef.
Repeat it back. Sorry, please.
Yeah.
Can you repeat it back?
That's fine.
Sorry.
Common mistake is where the both parties are mistaken. We know what the subject is, but we're mistaken about something fundamental with it. For example, its existence, which is like the oil tanker. And if it's something fundamental, then common mistake can apply. And the contract is what we say is void ab initio. It's not a contract. We go to the court. If we argue there's common mistake, there's no contract. All right. And the courts will say, yes, there is no contract. All right. You use other areas of law to get your money back. But fundamentally, there's no contract. And the same with mutual mistake. There's no contract. Okay. Look, Hina.
In the painting example,
Yeah.
it doesn't apply to the hard thing because he actually had something, right?
That's right. Well, he had something. More importantly, he had a painting. Yeah. Although to be honest, I think that Leaf and wasn't a particularly well decided case. I think that there are you could make an argument. Oh, you could make an argument that and a lot of people have, that Lord Denning got it wrong a little bit, but still, that's essentially the law that we've followed, and roughly represents what the law is now. It's something. It has to be absolutely fundamental to the contract in order for it to be common mistake. Courts don't actually like finding this common mistake. And it is pretty rare, because remember, this only applies if one party doesn't, or either party doesn't guarantee the truthfulness of that. Because remember, if the court had found that the gallery had guaranteed that it was by the famous painter John Constable, then they're in breach. That's easy. That's easy. Mistake doesn't come into it. The fact that they're mistaken doesn't matter if they've guaranteed it. It's when neither party's guaranteed it and it goes to the core of the contract where common mistake can apply. Okay. Now, look, those first two, they're corner cases. They're pretty rare. This one happens all the time, and the default rule is tough luck. No remedy. The contract stays, one person loses out. That is the starting point with unilateral mistake. Okay? The law, and this theme comes throughout, the law wants people to be careful. And if they're not careful, they suffer. That's how that works. All right? Now, there are some exceptions to that. There's two I'm going to talk about. The first one it's actually a principle from equity. It comes from the idea of things being done in bad conscience. And that is where one side is mistaken and the other side is not. And the side who's not mistaken finds out the other one's mistaken and actively takes steps to make sure they don't become aware of this mistake. Okay? And so the example in this case, Taylor and Johnson, it's from the 1970s, the facts, the case was heard in the High Court in the 80s, goes like this. Mrs. Johnson owned a plot of land, right? It was 10 acres of land, and it was worth about, I don't know, $80,000, all right? 10 acres, worth about, the market value was plus or minus 80. Now, she entered into contract to sell it to Taylor, and she entered into this contract for, I think it was $14,000 per acre. So how much would that be? $140,000. I'm just remembering the numbers just pretty broadly. Now, what was the problem? Well, the problem was she thought it was $14,000 per acre. Turns out it was $14,000 for all 10 acres. You can see what's going to happen here. You're going to have a winner and you're going to have a loser. And so, look, the court said in this case, because you've got to be careful, because you appreciate that she thought she was getting a pretty good deal. The guy wanted to buy it for $140,000. Nope. He realized early on that Mrs. Johnson was mistaken, and he realized it early on and took some steps to make sure she didn't go through it. So get the paper, get her to rush the thing through without her reading the whole thing. All right, and so all of this was adduced as evidence. The High Court, again, doesn't usually question the evidence. It's only the issues of law. And they said that, look, you actually can, in equity, only in these very narrow circumstances, you can actually seek what we call rescission. In other words, you can get the right to undo this contract, provided you do it quickly. And so here, she jumped in and tried to go through and make this argument to rescind this contract, purport to rescind it very, very quickly. It's actually a really important thing when we get to misrepresentation as well, that do not sit on your rights. If there is one overarching theme that I have with all of this private law that we learn about, don't sit on your rights. Don't think that you've got all day, all month, all year to do things. You don't. The courts will assist the diligent, not the tardy. Get onto things fast. That's how this works. So this right to rescind, she gets a right to undo the contract in equity, and she gets it because normally she wouldn't. Normally it would just be tough luck. But here the court said that, look, in this narrow set of circumstances where the other side's both aware and actively take steps to make sure she doesn't find out, then you can get a remedy in equity for unilateral mistake. All right. Now, this case, this next situation is bad law as far as I'm concerned. Bad law. All right, but it is still law. and this Pappas and Bianca Investments, the South Australian Supreme Court, they said, look, this is still law. It goes like this. If you intend to deal with a specific person, if I'm having a contract and I specifically intend to deal with Enrico, all right, and somebody comes up purporting to be Enrico, all right, and this is what happened with Cundy and Lindsay, by the way. Somebody came up pretending to be the purchaser of some handkerchiefs, 100 silk handkerchiefs, all right. If unilateral mistake will actually render a contract void, well, sometimes voidable. Again, this is not great law, and it's one of the things when I have to go and explain these rules. I'm going to tell you this rule, all right. I don't think it's possible I don't even assess this at all. I certainly assess the early one in equity, because this law is all over the show, and the reason for that is that in theory, if you're mistaken, if you intend to contract with a specific person and somebody else impersonates, the rogue we call them, in theory, that's not a contract. There's no actual true meeting of minds. The trouble is, this can manifest itself in a variety of different ways, and in particular, in the internet age, this can manifest itself in a huge number of different ways. This is why this area of law is just a mess. Because in Kunze and Lindsay, they actually said, yep, the contract can be voided for unilateral mistake, because these guys with the handkerchiefs only intended to deal with a particular company. And the fact that the rogue has taken the handkerchiefs and sold it to a third party, well, there's no contract. The third party can't get good title because there was no contract to pass that title to the third party. You just stop and think about that for a second. Oh, yeah, I'm expecting some questions about this one. Hina?
Sorry, I can't understand.
No. It's not.
You're saying something like we had to deal with a specific person.
Yes. So,
I don't understand.
if the contract, the way it's formed, we want to deal with a specific party. We want to deal with just Hino. So let's say, Hino, you have a business and you have a clothing business, okay? All right, let's just pretend you've got a clothing business and I sell handkerchiefs, very fine quality silk handkerchiefs, and you put in an order for 100 handkerchiefs, okay? All right, so I'm dealing with you, your entity, your business, say it's a company, or you personally, it doesn't really matter either way. I'm dealing with you and only you. Okay, that's the party who I've dealt with to sell 100 silk handkerchiefs with. If some person rocks up, okay, we'll call them, for the sake of argument, we'll call them Tala. So Tala rocks up, pretends to be you. She's the rogue for the purpose of this example. Pretends to be you. I give her the handkerchiefs. All right, and then the handkerchiefs are taken away by the rogue. Who owns those handkerchiefs? Who do you think? I'm going to actually put this to a poll, by the way. I'm actually quite interested to see who owns them. I'm going to put this to a poll. So just bear with me. I'm going to put this to a poll. We're going to do this. I'm going to poll. All right. And in this particular situation, let's just pretend, by the way, that Tala has on-sold them to Nathan. So I intended to deal with Hina. Oh, this gets a little bit tricky, doesn't it? Who owns the handkerchiefs? I probably misspelled that. Is it Simon? Is it Hina? Is it the rogue who's what did I say it was in the end? I think it was Tala I said it was in this case. Yeah. What? I'll just put the goods. The goods. So we're going to go Simon. We're going to go. It's a shame. This is the sort of task, by the way. Hina. Is it Tala? Or is it Nathan? Nathan, hang on. I'll put this up on a little poll. We can put it up on the screen. Hopefully that appears there. Look at that. Who's going to open this? So here, I've intended to deal with Hina. All right, but unbeknownst to me, a rogue has come in to impersonate her. So Tala has come in to impersonate her. She's taken the handkerchiefs and she sold them to Nathan. And let's just say at this stage. Tala has now disappeared. Who owns them? Who owns those handkerchiefs? All right. Hey, that's pretty good. Pretty good response. We've got 15 no response. Anybody going to click, click, click? I'm interested because it's even, which is really interesting. Okay. Nathan for now, but Gordy will lose. Well, maybe, maybe not. Because the way the law works is that this idea of unilateral mistake in this narrow case at common law actually says there is no contract. And as a very important rule, there's no contract. Title never passes. I still own those goods. All right? And assuming that no other little statutory rules like the sale of goods, there's some rules in the Sale of Goods Act, but at common law anyway. Hey, everyone, I love it. Rule of common law is that you can't give someone better title than we have. Well, we're not all wrong. In this case, it would be me. It would be me. There is no contract. And so, in theory, I can go to Nathan, pick up pick up the handkerchiefs and say, actually, mate, these are mine. Sorry. The remedy, remember, from Nathan's perspective, he has to go and find Tala. Now, assuming that Tala's the rogue and she's disappeared, Nathan's going to lose out. All right? But someone has to lose out. Someone has to lose out here. This is the difficulty with law. We're all about allocating costs. And this rule, this old rule in Kunze and Lindsay, which was also followed in Phillips and Brooks in Australia, if he pays, you can't pick it up from him. Well, if he pays me, sure, if he pays me, that's fine, but that's a different contract. If he's paid Tala, all right, he has to go and find Tala. There was no contract. Tala didn't have good title. She can't pass good title. Ah, lemon. So, unfortunately, Lewis and Avery said something similar to this. But what they said there is that when a person came to buy a car, they said that, look, they're really unfortunate. A guy went to sell a car to a person pretending to be the famous movie actor Richard. Oh yeah, leaving aside registration. Yeah, this is back. This case is before registration. All right. So back in the day, we're just using the old rules of common law. Back before cars had registration systems. The guy went to buy a car, and a guy pretended to be this famous actor Richard Green, who used to be this Robin Hood actor. You can Google it if you want. There, the court said that, look, in that case, sorry, Mr. I think it was Mr. Avery in this case. When the guy went to contract with the person, actually he intended to deal with the person standing in front of him, not the famous actor Mr. Green, showing the ID. All right? Unregistered mobile goods. Yeah, that's right. All of these things, we have to ignore the statutory framework. And so, unlike Kunze and Lindsay, he didn't actually intend to deal with the person Richard Green. He intended to deal with the person right in front of them. So that's tough luck. The guy's just given his car away, essentially. And so the car is gone. He has to find the rogue, pretending to be Mr. Green, get the car back off him. Okay. Will it be the same if the deeds are not clear? Do you mean the check? The deeds are not clear. I'm not sure what you mean by that. The actual actions, not property. Real property and land is different. Land is different. Yeah, real property works differently. We'll talk to that in a few lectures time. Okay. So anyway, unfortunately, this Shogun Finance and Hudson case, the British case, is a disaster because there a guy popped up pretending to be, I think, a Mr. Patel, but he'd used fake ID, and there the courts, again, in a split decision, some of them reckon Kunze and Lindsay was good law, other of them said that was bad law. And so, look, to be honest, we really don't know where this stands at the moment. But strictly speaking, at the moment, mistake as to identity is probably good law, but you're going to have to prove it. You're going to have to prove that you intended to deal with somebody, not the person standing in front of you. All right? It's an important consideration. Look, I'm I might actually just take a break at this point, guys. I'm going to have some water if that's all right. So I'm just going to pop off. I'm going to leave the thing going. I'm going to move the slide. Actually, I'll move the slide to the next one, misrepresentation. And then we're going to carry on. There's quite a lot of content tonight, and it's hard. You notice that trying to get your head around this is hard. So I salute you guys. It's going to take a little bit of time to go through and do. So, but I'm going to take just a couple of minutes. I'm just going to grab some water. So if you guys do have questions, I'll come and ask them for a few minutes. But I'm going to, grab some water. So, 2 minutes. Nope, I can't mute that mic too. I'm going to mute both mics. No, they don't go. Okay. I very sadly just found out that I wasn't getting dinner delivered to me. So there we go. Sorry about that. Took a little bit longer. Okay, here we go. You guys are still with us? Still with us? Good job. All right, there's a few guys here now. All right. So the next thing we're going to look at is one of the more important ones, which is common law misrepresentation. Okay, it goes like this. If there is a contract, all right, but a one, it doesn't even need to be a party. No, it doesn't have to be a party. It doesn't need to be a party. If you've got a contract, a validly formed contract, but somebody's lied to get the other side into it, what the courts like doing is saying, look, we're going to leave the contract itself and analyze the contract itself as if it were complete. But we're going to analyze this, these what we call these misrepresentations. Actually, lie is perhaps a strong word. If some untruth has passed from one party to the other as part of the negotiation, or that we're going to give you some form of remedy, and that remedy might be to undo the contract, or it might not. But the key thing to note here is that misrepresentations, I can't stress this enough, misrepresentations are not terms. Misrepresentations are not breaches of contract. All right, that particular point comes up time and time again, both in the undergrad and the postgrad subjects that I teach. Misrepresentation is a false statement of fact addressed by one party to the other party that was both intended to induce them into the contract and actually did so. I'll say that again, even though I'm just kind of reading from the slides. These are what's called the 4 elements of misrepresentation. Because these are elements, you must have all 4 things. But you can rock up to court if you can prove these things and seek some sort of remedy from the court. Okay? Now, this area of law, I mean, it's quite large because as you can imagine, people fib about all sorts of things all the time. But there's a couple of things I just really need to stress. Does this require the intention to deceive? Go. In fact, even better, I'll bring a little poll up. Polling. Does there need to be a lie? What do you think? Okay, it's still split pretty evenly. Does there need to be a lie? It is something that I cannot stress enough in our law and our legal system. And he said, there's actually one of the interesting ones because I've made this point about cheating being a quasi-criminal offence in India. I cannot stress this enough that most of the time when things rock up to court, and particularly where people are giving witness statements for things, particularly where they have no vested interest in the outcome, it is very common to have honest but mistaken people. Oh, I didn't read that one there. There was a question popped up on the screen. If the misrepresentation has been determined for the conclusion of the contract, I'll have to unpack that a little bit later. But this annulment, rendering contracts void is actually a little bit different to what we call rescission. But there does not need to be one side actually intending to deceive the other. All right, that's what you do need to intend to do is to be intending to get them into the contract. Okay, now this is going to take you a little while to get your head around, because you can give the other side information, genuine information that is just wrong. Lie, it absolutely does not have to be a lie. If I tell you, here's a statement. For example, I give out pamphlets in the mail. So Tyler, pick up one day, you read this thing that is in the mail, and it says, come down to Harvey Norman to buy our, these fancy, what's an example? Fancy computers. All right, what's an example? Our computers are, I don't know. I actually don't know much about the speeds of computers these days. 256 gigabyte solid state drive. Okay, there we go. I'm a Harvey Norman pamphlet. You've got a little pamphlet from Harvey Norman in the mail, leaving aside all the statutory stuff, and it says these new computers, they've got 256 gigabyte solid state drives in them. Cool. And they're $2,000. Cool. So you rock up, you go and buy $2,000 whatever it is, a $2,000 computer, right? And then you get home and realize that on the box and everywhere else and in the contract and in the invoice, it says that it has a 128 gigabyte drive. And you're like, hang on. You go back and look at the pamphlet. So we've got this leaf, you've got this document here that you received in the mail. And then you've got the invoice, which has all of the contractual information in it. And you've got to try and work out, okay, hang on. Is this a term? Now, you remember, what was that, last week, the week before last, we talked about the contractual intention test? Remember that this and this can be considered part of the same contract if you satisfy the contractual intention test. All right? We'll just assume that we can't. We'll just say that this was given to you 3 weeks in advance. All right? And this contract specifically says in it, the terms specifically say, this is an all-contained document. All other statements aren't part of the contract. So the representation, the mail that Tyler's got in the pamphlet you've got in the mail has, possibly an error in it, or possibly they intended to deceive you. All right? You have to stop and think about that. Hang on. This document has a false statement of fact addressed by one party, Harvey Norman, to another, Tyler, intended to induce her into a contract and actually succeeded in doing so. If you can prove those things, Tyler can rock up to the court. She can succeed in misrepresentation. But this, assuming that it's not a term of the contract, it's not a breach. Knowing that distinction between these two things is actually huge. Because if you rock up to the exam and you're writing that that's a breach, but you haven't talked about, or even worse, I've seen this in the past, people talk about the contractual intention test, say that it's not a term, and then say that it's a breach of contract. Now just going, oh, I'm not winning. Okay. So misrepresentation is a common law action that I knew this would happen. It lets people seek some sort of remedy, but you have to satisfy those 4 things. So the first thing you've got to note is that the statement that's made has to actually be false. All right, and we use a reasonable person test as part of this. And I actually had an argument about this particular case, this Mitchell and Valheri. I had an argument with one of my good friends who's also doing stage 1 contract law, and Professor Stephen Graw, about Mitchell and Valheri. What's the difference between a computer shop advertising and the Pepsi advertising when playing? It is absolutely on point. If you look at the slide here, that bit at the bottom, puff is never a representation of fact. All right, so it's not fact. And so therefore, whether it's false or not, it doesn't really come into it. Now, I'll tell you about Mitchell and Valheri because I had to go and reread it a couple of days ago to prove that I'm not going crazy. Because in that case, there was actually 3 judges in the South Australia case where there was found to be, at the lower court, the judge said the statement and remember this comes up, we were talking about this a couple of weeks ago. The statement was immaculate condition, nothing to spend. Okay, immaculate condition, nothing to spend. That was the case. And so because it was a contract for the sale of land, that representation cannot be a term. Okay, can't be a term. Why? Because contract for lands have to be in writing, and only that document has the terms of the contract in it. So it cannot be a term of the contract. So where the judges there were trying to work out, was it a misrepresentation or not? So immaculate condition, nothing to spend. And so the judge at first instance said, this is a misrepresentation. All right. Now the 3 judges in the South Australian Court of Appeal, this is where I kind of lost and kind of won. Why? Because the argument was that they tried to make was that it was puff. Oh, it's just sales puff. It's just real estate agents going through and talking up the property. And so of the 3 judges, one of them in the minority, he said, this is not puff. It is a statement of fact and it is false. Nothing to spend. The house was structurally unsound. All right. The Chief Justice in the majority said, this is just real estate banter. The statement, nothing to spend, has to be read with the statement before it, an immaculate presentation. You read it as one thing. Therefore, that is puff. Okay, and kind of unfortunately, the other judge, and so therefore, by the way, if it's puff, it's not going to be a misrepresentation. The other judge said, kind of unfortunately, this statement is not puff. All right, it's not puff saying nothing to spend. That's not puff. That is something, puff is something that no reasonable person would have any legal effect. No, that's not the case. However, it says nothing to spend means you can just walk into the property. It's not making any representation about the structural integrity. It just says when you walk into the house, you don't have to pay anything else. And so the 3 judges disagreed about what the actual term meant. But what the second judge in the majority said, when he's saying it's not puff, but it is not false. Because it's not false, it's not a misrepresentation. Therefore, 2 judges to 1, not a misrepresentation, the real estate agent wins in the South Australian Court of Appeal. That's how that worked. Okay, that's probably clear as mud to you guys at the moment, but it is one of those, I think, a good illustration of where judges can disagree, and they're disagreeing and giving different reasons for disagreeing. So if you have got Steve's textbook, we're both right. I was quite happy with that result. Makes a good moot question. Okay, so that's the first thing to note, that the statement has to be false. If it's not a statement of fact and it's not false, it's not going to be misrepresentation. Now, the next thing we need to look at is that the statement has to be one of fact, all right? And that is different and distinct from some other sorts of statements. And the main one of those is a statement of opinion, all right? So if I'm giving an opinion about something, it's my opinion, it's not usually going to be considered to be a statement of fact. All right, so if, for example, I'm going through, and again, here, for example, instead of Tala reading a pamphlet at her house that was delivered by Harvey Norman, let's just say I'm Tala's friend who works at Harvey Norman, but isn't the person making the contract, all right? And I say, oh yeah, I think that those computers have a 256 gigabyte drive. Yeah, I'm pretty sure they do. Those $2,000 computers that they're selling down there, yeah, I think it does. All right, that arguably is a statement of opinion, not one of fact. All right, but, and that's the sort of exception to this rule. A statement of opinion is not usually a statement of fact, but there are some rules. So that's an exception to the main rule, and there are some exceptions to the exception. All right, and there are these 4 things under this here. So look, if I didn't actually hold that, in other words, I was just fibbing. I actually didn't think genuinely that it had a 256 drive. I didn't actually hold that opinion at all. For example, if someone just told me, I just talked to someone before and they said, yeah, it has 256 drive, and I just repeat that. That's not a statement of opinion that I'm actually holding. All right, it's not my opinion. Also, a statement based on tracks known to be untrue. So in other words, if I've said this to Tala, the person has come to say, oh, no, me. If I've come to say this to Tala, and I know darn well that it's got a 128 gig drive, all right, and I try to say that, oh yeah, in my opinion, it's 256 gigabyte drive, that's not going to work either. And statements of future intention. These are a particular class of representation. If I say to Tala, we'll say we've got a different scenario. I'll pick someone else in the class. I've talked to you guys too much. Rizvi. If Rizvi is going to buy my land, all right, and I've got 2 packets of land, one next to each other. Now, if I go and develop one of those lands and sell the other one I'm selling, the value of that's going to go up in value because I'm putting developments next to it, and that's going to increase the value of land next to it. Right? If I say to Rizvi, yeah, I'm going to go and develop this land. I'll sell you the second packet of land, all right, and I'm going to develop the first packet of land. And you go, oh, okay, cool. That sounds good. If, however, when I went into that and to make that statement, I had no intention of ever developing the land. I just wanted to sell it for a premium price, the one of those packets. That can be deemed to be I guess, an exception to the exception, and it will be considered a statement of fact that is false. So that can be a misrepresentation. However, if at the time I went and made that representation, so I said, yeah, I'm going to go and I'm going to develop this property. I'm going to sell you the packet next door. I'm going to develop this one. Then I get sick, all right, and I don't develop it. I change my mind. At the time that I represented that to you, it was genuine, and now it's not. In that situation, it is going to still be considered a statement of opinion, and it will not be a misrepresentation. So this is hard, this area of law, because these are exceptions to the exceptions. So you've got the 4 elements that you need to prove misrepresentation. One of them is that it has to be a statement of fact, all right, not a statement of opinion. But some statements of opinion were actually deemed to be statements of fact. In other words, they're going to satisfy that element. But then again, there are some exceptions to those as well. Hina.
If I'm selling a land to someone with the intention of not building up and just saying at that time that I'm going to build up, can that be considered as an opinion? Because that is not opinion, because he's already gone inside. He knows he's not going to build the land.
Yeah, it's not an opinion.
But in one case, when
Yep.
I'm planning that I'm going to build, but I get sick and I cannot build it,
Yeah.
that can be a statement of opinion. But if I'm already planning not to do something, can it still be considered a statement of opinion?
No, that's the whole point. It's not an opinion that you are actually held. So it's this the second one down there, Beach Petroleum and Johnston. If I didn't actually hold that opinion, which is what we have in this case, if I didn't actually intend, if I told you I was intended to do it, but I didn't actually intend to do anything, that's not a statement of opinion. That is not, I didn't hold that at that particular time. Look, all of these things are obviously subject to proof. You've got to go through it. I, as the plaintiff trying to bring an action of misrepresentation, would need to prove that. But if I could prove, usually, by the way, through written documents, if I've seen written documents or I can adduce to court written documents that say, we've entered into a contract to try, or negotiations to try and sell the land to a third party. All right. If I'd entered into, I was going to go to you. Oh yeah, going back to this example with Rizvi. If I had said, oh yeah, I'm going to go and develop this land, so I'm going to sell the one next to you. All right, for more. And if Rizvi could prove through finding some documents that I just at the same time was negotiating to sell my packet of land to a third party, clearly I didn't actually hold that particular opinion. Clearly that is not going to stand, and so it will be considered to be a statement of fact, and it will be held to be a misrepresentation, or at least it satisfies that element. If that makes sense. The best way to prove things is to doing things in writing. So if you have documents that you can go through and have those things. Okay, I'll move on to the next one. What are we? 8 o'clock. So, silence. What does that mean? It means when somebody asks you something about a contract, if you do not reply, at common law, that's okay. Or rather, it's okay. It's not a misrepresentation. Okay, so it's a really important thing. And so Keats, for example, was a case involving a house that that he had leased to somebody. I think the Earl of Cardigan was the one that was the person doing the leasing. And Keats moved into this house, and the had asked the guy, is it good to live in for a family, and didn't reply. So he bought the thing anyway, wandered in. The place was an absolute, total, and utter dump. All right, but the guy, the Earl in this case, hadn't made a positive representation that it was good, had just not replied to being asked. In that situation, they find it common law. It's actually too bad. By default, silence will not be a misrepresentation. It's tough luck. And again, the common law is quite harsh. It's different from the statutory stuff that we'll do in a couple of weeks' time. At common law, silence is not going to be a misrepresentation. It's just tough luck. The other person had to check. Now, again, there's some exceptions to that because the where things are half truths, where you make a statement about something that is not. Let's think of an example. Where you make a statement that a particular, in this case, the purchase of a business. In my this business, how much money is this business going to make? Oh yeah, it'll make. I reckon it'll make about $100,000 a year. All right. Now, or even better, it's made $100,000 every year in the last 5 years. Okay. That's fine. It seems like a pretty reasonable sort of a statement. All right. And what, however, if I knew that the lease was up and there was no way to renew the lease on the place, all right, and no other buildings could be found to run this particular business from this point forward, that's kind of a half truth in that. When you say that, $100,000 at that you've run it at $100,000 up to this point, and this is true, but it's not really telling the full picture because you were able to do that because you had a lease up to a certain point. That's with those things there. So just be a little bit mindful with some of those cases, those situations where if you don't have to tell people things, and if you don't tell people things, all the better at common law. The statute works differently. The Australian consumer law works differently to this. Again, we'll talk about that in a few weeks' time, and so I'll come back and refer to this. But by default, you don't have to do that. Whereas you can make a misrepresentation if you make a statement at a particular point in time, right? But before the contract is formed, that statement that you've made has become false. So, for example, if I'd said, yes, this business makes $100,000 worth of revenue, right? And I made that statement 18 months ago, and since then, my clientele has dropped off considerably. All right, now I'm only making $50,000 a year, but it took us 18 months to process the paperwork. I've become aware that statement that I've made, which isn't a term, because if it's a term, we don't go through any of this. If it's not a term, it's merely a representation. All right, at the time I made it, it was true. Later on, it became false before the contract was formed. That's the key piece of information here. If it becomes false after the statement becomes false, you've got no responsibility after the contract is formed. Okay? And these particular types of contracts have different rules. Vina.
I didn't understand that. If the whole state has been formed before the contract?
Yep. So no. If a particular statement that you've made to a person you're about to enter into contract with is true when you make it, but becomes false later, that can be held to be a misrepresentation if it happens and becomes false before the contract is actually formed. So if you're going through a process of negotiation, for example, you make a statement back here.
So can you just tell the example again, the one which you told about this statement?
Sure. So the statement to do with the selling of a business. So let's just say I'm going to buy a business of you, Vina. So Vina, or rather, you're about to buy a business off me. And I've told you when we talked about it 18 months ago, this business, my tax agency business, for example, generates revenue after expenses of $100,000 per year. It has done for 5 years. All right. It generates $100,000 per annum. Sure. And let's just say we talked about this 18 months ago, and we said, look, I'm going to, and you said to me, look, I want to buy your business. We'll map this out. We're going to put this into a contract. Okay, cool. So we go through and do some further negotiations, all right? And 18 months later, we go to buy the business, all right? Now, if I had known after the time I made the representation of $100,000, that was $100,000, that business dropped off dramatically with a virus or what have you, and now it's only making $50,000. If I knew that, all right, that became false before the time of formation of the contract, when the contract actually comes into existence, that can be a representation, even though I honestly and reasonably held it back at the start. Okay, if it becomes false later, but before the time of formation, that's the key thing. So contracts, remember, we can talk about contracts, have negotiations over a long time. This does happen in business. You can negotiate stuff for a long time. Things that you've said at the start that have become false at some stage later but don't get revisited, all right, can still be misrepresentations. So just leave that. Hina.
Okay, the same scenario, like 18 months before I said something.
Yep.
At the time of purchase, things have changed and I decided not to tell. That is misrepresentation. And suppose everything was the same at the time of sale and after sale things changed. Then is that a misrepresentation as well?
Okay, the first I'll just deal with the first one first. So the first point in time, you've said something which is true. All right. Later on, it's become false, but we haven't formed the contract yet. All right. So this is still a statement. We've satisfied the other elements. This was a statement that was again, it was true, but all of the other elements are true. It was addressed to the party misled. It was designed to induce them into the contract. Actually, did or was material in inducing into the contract. False, and it's a statement of fact. All right. But at the time I make it, it was true. It wasn't false, right? Later on, it's become false, right? But we haven't formed the contract yet. That can be a misrepresentation, yes. If it happens after formation, no. No, if the particular thing becomes false here, that's fine. That's fine. That doesn't form part and parcel of it. That's just bad luck. And in this case, with the business, if you think about it, if the business was earning $100,000 per annum all the way up to the point of the contract, then it falls off to be $50,000. That's just tough luck for the purchaser. That's just tough luck. That's where the loss lies here. There's no misrepresentation there. Okay, but these two particular types of contracts, what we call an ubamari fide, of utmost good faith, that is contracts for things like guarantees and insurance. If you think you're going to get away with not telling the insurance company about things that are material, you are going to lose, because the common law and the statute, by the way, protect insurance companies. There's protected monopoly. So when you're insuring things, make sure you tell them everything, because you will lose at common law as well as under the statute. Also, science and fiduciary relationship. A fiduciary relationship includes things like company directors in relation to the company, employees in relation to companies, trustees in relation to trusts, business partners in relation to each other. What we call these very, very high standard of duty that we impose on people for these very, very particular categories. If you don't tell your business partner about something when you're engaging into a contract with them, that silence and not telling them can be held to be a misrepresentation. And so remedy can arise at common law there. Okay, I'll talk about fiduciary duties because there's a lot to it when we do the week on agency and trusts. Okay, the next slide of misrepresentation is inducement. Now, look, key thing to note here is that, we got twice, sorry, don't go too far. This is the last element. Remember that you have to both intend to induce and actually succeed in doing so. All right, so there's a couple of there are a couple of exceptions to this. One of them, the first one, is that if you know how I said that the statement has to be addressed to the party misled, has to be false, has to be intended to induce them to the contract, actually succeed in doing so. What's the other one? Intended, false, and it's got to be a statement of fact. That's right. Now, all of these things can be satisfied, right? Except that if they never actually got the pamphlet. So, for example, going back to the very first example that I used, if Tala, after she'd bought the computer, picks up this document that says 256 gigabytes and then goes and looks at her thing, she can't turn around and argue that this is a misrepresentation because she didn't know about the statement, the false statement, at the time that she formed the contract. Not misrepresentation. It can't be. Similarly, and this is a good one, if Tala rocks up to the store knowing darn well the computer only has 128 megabytes, all right, and that she knows darn well, and then goes and buys the thing, and then goes to try and complain it was a misrepresentation, she can't win there either. All right, so there's that part of it. This third thing here in Redgrave heard that the statement itself has to be material in making the party actually enter the contract. If, for example, there were 10 reasons why you want to enter into a contract, and the misrepresentation is only one of them, the courts might not say that that's material in actually inducing the party into the contract. They have to really rely on the representation. It has to be material, not substantial. It doesn't have to be the only reason, which is the Gordon Vargalis, but it has to be. It can't just be one of many, many, many reasons. All right, it has to be, you know, a decent chunk in order to be a misrepresentation. If you had 3 reasons, this was one of them, that's probably going to be fine. If you had 10 reasons, and this was only a very minor part, the statement that was made to me. So, for example, let's just say Tala needed a computer that day. All right, didn't care what she was going to get. She saw this ad, sure, oh cool, 256 gigabytes, great. Doesn't make any difference to her. She needed a computer anyway. You could make an argument there that wasn't material in actually making her want to go and buy the computer from Harvey Norman on that day. And finally, that statements after formation. You can't make a misrepresentation after the contract's been formed. You can't. You didn't. If you think about it, if a contract's been formed, you're not inducing anyone into a contract with a statement. You can't, because they've already entered it. Does that make sense? That last bit has to be, so those things. These bits are a little bit more, I think, are a little bit more straightforward, these particular parts. But they do still need to go through and doing. And I'll probably, when we talk about the misleading, deceptive conduct, Hina.
The first 2 points, they're confusing. Like in one case, it's saying, in both cases, it's saying it's not misrepresentation.
Yep. All right.
Other parties never knew, and it's no. In both of the cases, it's saying the same.
No, it doesn't. No, the one is when the yeah, sure. Going back to the example with Tala and the pamphlet, right? If she never read the pamphlet, she never even saw the pamphlet, and picked it up, like afterwards, and went, oh, after she'd already gone and bought the computer, she never knew about that statement. It could have been under her, in her mailbox, given to her. But if she never knew about it, she can't argue that it's a misrepresentation. She never knew about it. So clearly it kind of induced her into the contract. Does that make sense? Whereas the admittedly rarer situation is where if she does know about it, she's seen it, she's read it, and she looks at it and goes, oh no, those computers don't have that. They can't. If she knew that statement is false, it can't be a misrepresentation because it didn't induce her into the contract. She knew that it was false. So she can't turn around and argue, oh, this induced me into the contract. Sorry, Tala, getting picked on. You can't turn around and say this is misrepresentation if you knew darn well that it was wrong. So a lot of these things, they come up they flow from sort of, this is a reasonably logical part of of this action. It's really designed to give people this remedy. And we'll talk about what the remedies are a little later. All right, so we're going to move on to the next vitiating factor. I did warn you guys, there's a lot of content here. Duress. Duress is it's a common law action. It's actually relatively recent. When I say relatively recent, it's less than 100 years old. And look, it's actually to do with what we call, look, it uses the phrase illegitimate pressure, but it's coercive pressure. This is where you are directly and overtly exerting for some form of pressure over another party to get them to sign a contract. Okay? And it comes in three flavors, either to the person, to their goods, or to their what we call the economic interests. All right. So we'll start with the first one, which is duress to the person. Duress to the person is pretty straightforward. It just involves some form of actual threat, both either to a person or to their associates. So let's just say Kamal and Kamal has a contract with Elizabeth, all right, or wants to enter into a contract, or Elizabeth wants to enter into a contract with Kamal, and she says, he said, I've got actually no, I'm going to make up some names because these things come across really bad. So I'm entering a contract with my friend Gareth, and Gareth calls me up and says, or even a third party calls me up. Our friend Skeeny calls us up and says, if you don't sign this contract, Simon, I'm going to come over and bust your kneecaps. All right? That's threats to a person. And look, in the olden days, you didn't actually have duress. You actually used to just say, well, if somebody's threatened you, you can use if they threaten you, that's a tort. You can just you go through with the contract, then you try and backtrack it. It's not what they do these days. The courts interpret these things quite strictly. If you can prove that you are under duress, somebody's threatened you to get into a contract, it's a very straightforward mechanism, and it is a self-help remedy. What does that mean? If you reckon you can prove that someone threatened you, and for example, to enter into contracts to buy your goods, all right, you know what you can do in the middle of the night? Go in, get your goods, assuming it's safe to do so, and bring them back again. It's a self-help remedy. Doesn't require the court to intervene. And look, it's a pretty straightforward sort of a thing. Threats to the person is always going to vitiate a contract. You're never really truly having a meeting of minds. Okay, threats to goods. Again, these they did try and have this argument that you just sue the party for go through with the contract because you've been threatened, or you just let them destroy your goods, and then you just sue them in tort. It's like, no. And the court said, no, that really doesn't work. In Hawker Pacific and Helicopter Charter, that involved a helicopter charter business, so they would have tourist flights and surveying flights and all sorts of things onto mining sites and all sorts of stuff. And they entered into a contract with Hawker Pacific for them to paint these helicopters. All right, that's fine. So while they're painting, these helicopters are partially painted. All right, and Hawker Pacific, all right, is halfway through this, and they've realized they've underquoted the job. So they demanded that Helicopter Charter pay them in order to enter into a contract to pay them a bit extra in order for them to return their own helicopters. Seems a little bit mean, doesn't it? And Helicopter Charter were like, look, we've got these contracts. The contracts are massive. We need these helicopters now. Okay, sure. We'll enter into this contract. We'll sign this. Sure. And then it went to court. And the New South Wales court said, no, that was under duress. You were promising to not give back their helicopters, which incidentally you're actually allowed to do if they haven't been paid for, until they'd entered into this new contract. Therefore, that's duress to the goods themselves. Okay? And you can also have this third type, though, what we call duress to economic interests. All right. And this can actually come up in business. This thing may actually come up in your professional and lives, because the main time this comes up is when you have a powerful player and a weaker player. So if you are dealing with a large entity and you're a business, you're dealing with them and you've got a bunch of contracts, all right, with them. If they say to you, if you don't sign this new contract selling us your goods at a much cheaper rate, we're going to tear up all of these earlier ones. We're just going to not pay you, not do them, not fulfill them. We're just going to breach. All right? Now, Sure, you can argue that there's been breach. Sure, you can go through all of that process. But threatening to not complete a contract that you're an existing legal duty is strictly speaking, it's unlawful conduct. All right, that is a threat that the courts consider to be illegitimate, and as such, you can argue duress. So the new contract that was formed under that they're coercing you into doing, later on, you can go back to the courts and say, actually, they threatened us to breach all of these other contracts. Usually you want to do that after you've fulfilled all of these contracts. Then you're trying to get this one reversed. It's usually the strategy that you go through and do those things. I think what I might do, those slides are probably all right in terms of the underlying assessment. I don't usually assess duress very much because it seems like it comes up a lot. That last one, that does come up a little bit more often than the others. I mean, if you're dealing with the mob and they're threatening to break your kneecaps if you don't sign into a contract, you've got other problems that I can't solve in business law. I'm sorry. You're going to have other dramas. You have to use other areas of law or other aspects of your life to go through and resolve some of those things. But this idea of threatening to damage the economic interests elsewhere, that is one where that can come up. All right. You guys are going to need to know this stuff. Oh, undue influence. You're going to need to know this for your assessment. You're not going to know how or why until you've gone through and read the Australian Consumer Law, and we've done that part, but you are going to need to know these. All right. Well, the thing I need to just explain right from the offset, though, and the first year's had a hard time with this. You can go to the court under what we call the general law, the common law, and have an action, a cause of action, in undue influence. If you can prove either there was a relationship of trust and confidence or a direct overbearing of the will of the weaker party, usually. You're the one who wants to get out of the contract. Now, that is a cause of action. You can go to the courts and try and prove that. Now, you might notice somewhere in the Australian Consumer Law, they use the same phrase. All right? They use the same phrase, and you're going to have to work out how that fits in that statute when you go and do that assignment. Because you're not bringing an action in the general law, we're bringing an action under the statute. So you have to know how you would prove this particular point in law. It's the exact same thing. It's the exact same thing. We're proving that there was undue influence, but we're not asking for the remedy in the general law. We're asking for the very, very, very good remedies in the Australian Consumer Law as a result. So you still got to do the same thing, still got to prove all of these points, but we're going to use the statutory framework to reach the particular result that we want. Okay, now let's go. So undue influence, actually no, we'll jump back just for a second. Undue influence is usually to do with family things. Family things where this comes up, or it can be situations where one person has essentially set themselves up in somebody else's life. And again, this is to do with personal life and personal law. The classic example of this is when you're really old, if you have a housekeeper, it's a really common thing. The old, usually, I'm going to be gendered, so usually an old guy, falls for the housekeeper and falls in love because they've been, helping them for so long. They've got this relationship that they've built up of trust and confidence, and eventually he starts showering her with gifts, or, most importantly for us, enters into contracts. And that usually the children, by the way, when they realize that the old guy dies, and the children realize there are all these contracts, it's usually the children trying to bring an action, or get the executive to bring an action to have those contracts overturned. Okay, so undue influence is a vitiating factor, and it can arise in sort of two broad ways. One is involving a relationship, and the second one is this direct overbearing of the will, which I'll talk to a little bit later. The relationship one's really more important. Okay, so we've got these two types, and then the special relationship type splits into two as well. So there's two broad level types. The special relationship, which is the important one, has two types that sit under that. I'll flick that over now. Okay, so The first of these two types of special relationship are what we call an established category. Okay, an established category means if there is a contract between these people, the courts will automatically find, by default, that there is undue influence. So by default, and again, we've got some exceptions to these rules, but by default, if you are having a contract, no matter how you've managed to make this look like a third, an arm's length transaction between parent and child, guardian and ward, doctor, patient, solicitor, client, trustee, beneficiary, religious advisor, and disciple, that is an exhaustive list. In other words, there aren't more. So these are special categories of relationship. So if I pick somebody in the class again, if Elizabeth is my religious advisor, in fact, this may be a thing, by the way, when you're coming up and you're looking at the your assignment, and I can argue, and I managed to argue. So let's say Elizabeth is my religious advisor, and she comes to me one day and says, "Simon, I'd really like to buy your house." I'm like, "Oh, that sounds great. Oh, you're so good. Oh, thank you very, very kindly. I'll sell it to you at a super, super cheap rate." And she says, "Okay, thank you very much." Now, by default, I usually, when I realized later on that, hey, hang on, that wasn't very good. Often though, when people they either snap out of it or they die, and it's family members, usually the executor, who are much clearer of mind, go through to try and overturn things. They're trying to vitiate that contract, and by default, if you and Elizabeth, if I can prove that she's my religious advisor and that I'm her follower, that's it. By default, undue influence will be presumed in this first category of special relationship. And the important thing to note here, this has come up for me in legal practice a few times, is that if you have a power of attorney, that's a statutory framework where you can give power for people to do and deal with your goods and deal with your healthcare issues on your behalf, and you can do it ahead of time. Powers of attorney. It's the idea that you, particularly as we get old, or if we're about to go into hospital, or we become mentally infirm, we can go and let people deal with our affairs, usually for our best interest. But if that does happen, you can't have a contract. So if you have a power of attorney over somebody, you can't have a contract with them, or rather, it's undue influence is automatically assumed, okay, by default. All right, so these are the special relationships. There's a finite list. There's only a few of them. Now, what, however, instead of there being with Elizabeth, who's my religious advisor, we'll say we've got Gaetano. Gaetano is a long-term friend of mine. So much so that I listen to his advice, and I almost get into the habit of kind of doing what he says. All right. What the courts say though is that these other relationships, you have to prove them on the facts. So what I would have to do in order, again, to try and get this contract overturned for undue influence, to prove undue influence, I would have to say, look, this isn't strictly one of those categories from the previous slides, because Gaetano is my friend/student, but because I've known him for so long, if I can prove that a relationship of trust and confidence exists, so much so that my will would always be overborne when engaging in transactions, or my will would be heavily influenced engaging in these transactions, then I can argue that undue influence applies. Okay, if we're not an established category. And so notice that these other categories are here, by the way, are not established categories. You would have to actually prove, in husband and wife relationships, by the way, that this was such a strong relationship of trust and confidence that one person, in this particular set of circumstances, would almost always do what the other one says. That's sort of the level you have to go and deal with. So you would have to prove that you're Hina.
Yeah, I have a question.
Sure.
Like in this type of relationship, when the person is deceased, whom does the court favor? The children or the person to whom they have?
No. Okay. No. What? Okay. So when the court, strictly speaking, the court doesn't favour anyone. In fact, that's a fundamental rule. But what you find is that when a person's mind is overborne, they don't want a lawyer. They don't want any help. They don't want the contract overturned. They don't want to do anything. They've gone, given their house to somebody for a cheap amount. They don't want to go through and do it. When they die, the children want it done, and usually the executor, because the executor is responsible for following the will and wrapping up all of the affairs to try and get the best amount of money with it. Now, if there's been a really bad contract that's been made, the executor can go to court, and the executor can argue that that relationship that happened was one of these. So even if it's not an established category, it could be one of these special relationships that can be proved on the facts, this relationship of trust and confidence. Like Johnson and Buttress, that was where an older guy had a woman who would come and look after him. He was very fond of her. She would come and stay. She would care for him. And when he died, the kids went to court and tried to argue under influence. And the kids won. They said, at the end of the day, yes, the transaction that she'd had with him, when he sold her the land for a cheap price, it's a relationship of trust and confidence that was proved on the facts. All right, it wasn't an established category. So if you're having contracts with your siblings or your brothers-in-law or your fiance and stuff, by default, you're not going to get undue influence. You'd have to prove in this particular set of facts that your will was always overborne. That's what you've got to go through and prove.
But there was a case in which an old lady, she gave most of her whatever she had to a person who was helping her rather
Yep.
than her children, and
Yep.
the lady who got the property, she won it.
Yeah. So there's a case here. Not even with this one, but to do with religious advisor and follower. Orchard and Skinner is a case where that happened, where a woman's went to become a nun, so she sold all her property to the church for a very cheap amount, and she went to be a nun for 7 years, and then after a while, after like 8 or 9, 10, 12, 13 years, she's like, this wasn't what it cracked up to be. You're my religious advisor, I'm your follower, I want my house back. And the court said no. They said no, though, because she took too long. So that there can be some other reasons where this can come, where these things can come over, and there's also some excuses too. So there are some ways that you can rebut these things if you are the person who wants the contract to stay on foot. So if in the case of Johnson and Buttress, the housekeeper who wants the contract to stay on foot, they can jump through and do some things. But, and this is an important point, when we look at undue influence and we look at unconscionable transactions, the defenses to these are the same. So I'm going to do them a bit later in the lecture together. So I'll talk about that. So that you might find, I'm not sure which case you're referring to there, Hina, but it might find that one of these defenses was made out. So we'll come through and have a look at that. But first I'll just mention, remember I mentioned that you've got the special relationship of trust and confidence, which is either established category or established on the facts. This idea of this undue influence or actual undue influence is where there's what's called general domination. Again, usually this happens where one person gains some form of advantage over another by somehow controlling their mind. And look, cases where these comes up are things like the religious cases as well. Strictly speaking, it's not the religious advisor and the follower, that's an established category, but you do find that that when people go and are engaged with people over a long period of time, even though it's not a relationship of trust and confidence as such, they can go through and demonstrate that a person's will has been overborne. This is very hard to prove, by the way. That's why I don't spend too much time with it. You can have situations, though, where a person can get a temporary advantage where, and again, this is usually to do with sort of personal type lives, where there's some form of veiled threat. It'd be really great. It's a shame you're not going to sell me that house. I'm just going to have to sell it. I'm just going to have to go and buy a house, and I'm just going to live in poverty, and I'm never going to come back and visit you because I can only buy a house in the in Charters Towers because I don't have enough money. And you go, okay, I'll sell you my house really cheap. I know you don't have much money, but it would be really good if you stayed here with me, and I don't want you to leave. That idea of this temporary advantage that one person secures over another, that is again, the person who wants to get the contract overturned has to go and prove it. And again, usually they don't want to prove it because they're the ones that does that. But what you do find is that once they've done the contract, and I've seen this happen in practice, sometimes people will do the contract to buy or sell them a house at a really cheap rate. Particularly men. Men are, no offense to the blokes in the class, men can be a bit silly when it comes to love. Sometimes they'll fall in love with somebody and then they'll buy them a house, or rather they'll sell them a house at a particular cheap rate. Usually, again, this only works in terms of contracts. Oh, I've got lag. Okay, I'll turn my screen off. Okay, we might be having streaming problems. That is not good. All right, well, I suggest I'll just enter the chat. Okay. Hi. Uh-oh. Collaborate's crashed. Oh dear. That's not good. Oh, collaborate. You died on me. Okay, I'm just going to have to jump out and jump back in, guys. Oh dear. Now it's possible you guys can still hear me or it's lagging, but I'm just going to drop out and drop back in. So those that are hearing on the live stream, my browser has had some dramas. So if you guys are on the live stream, you'll be able to hear it. I'm just going to reboot my browser, and I'm not going to report that to Microsoft, and just reboot it. So we'll see how we go. Good, Google Chrome. All right, let's go. So, carry on talking about undue influence if you like. We might as well on the stream. So if we were in the situation where there was this threat to do something, usually the person who's under undue influence doesn't want to do it. Often it's done by family members that come to the party late in the piece. Oh, this is really bad. My Chrome is just dying on me. Okay, let's try that again. All right. So again, if you guys are on the stream, I'm just restarting things. My computer has just decided I don't know why. Just now it's gone through to go through and reboot, so I have to do a reboot. Oh, come on. All right. So we're having all sorts of dramas here. Okay, guys. I think what I'll do is I'll carry on the stream because it's going to YouTube. So we're going to just carry on talking about the. I'm really, really, really upset about this. Come on. No, the Firefox nor Chrome is working at all for me now. This is crazy. What is happening here? Unbelievable. All right, come on, Chrome. All right, so I guess what I'm going to do, I'm just going to carry on for the benefit of the live stream. I'm going to carry on talking about the things that that you guys are going to go through and have for this. So that's probably enough to talk about actual undue influence. Look, it's pretty hard to prove with all of those things, so it's not going to come up with any probably not much in your professional lives anyway. All right, but what can come up within in our professional lives is this idea of unconscionable conducts. So I've got unconscionable dealings here as a um, a heading. I'll see if might actually be jumping back in. Oh dear. And unconscionable conduct. Oh, are we back? How's that? Probably lost everybody at this point in time. Oh, you can hear? Okay, that's good, guys. I just had to close Chrome and redo it. So there's really not too much to say in undue influence. It doesn't come up very much in your. It's usually to do with private life, but this one can come up. I actually had something like this come up with me with a business thing a little while ago, and it's not nice. Law isn't particularly nice as an area, but this is where things end up being a little bit problematic. So anyway, I mentioned a case a few weeks back called the South Australian Railways and Egan. And there, Justice Menzies looked at this contract and said it was the most unfair, awfully one-sided, terrible contract that he'd ever seen in his entire judicial career. Nonetheless, he said, look, at the end of the day, it's still a contract. And so, as such, it's not going to do anything about it. And so, the common law doesn't intervene when contracts are unfair. However, equity can intervene and does. And now the key thing you need to note is this magic phrase here. And this comes from a famous case called the Commercial Bank of Australia and Amadio, and where the statement of legal principle comes from. It goes like this. In Amadio's case, there was a young guy, and his parents were Italian migrants, and they didn't speak English very good. So you've got the parents are Italian migrants. English is not so good. And the son had a business. And as far as the parents were concerned, the business seemed to be going very well. How could they tell? Well, the son had all sorts of fancy new cars, and he had all sorts of new clothing, and clearly his business must be doing well if he's able to afford all of these things. You can see where this is going. The accountants in the room are going, oh, okay, we can see where this is going. So one day, this young guy approached his parents and said, Mama, Papa, I'm not going to do the accent. Thanks, Enrico. Cheers. But one day, come to them and said, look, look, the bank manager's coming. Can you guarantee me a loan? I only need it for a little bit. I've run a little bit short of cash. It's just to tide me over for a little bit, and then I'll be back on my feet again. And again, the parents were like, oh, sure, no dramas. And so the bank manager came, and the facts are kind of important because the bank manager came to their house while the parents are there at the table, and the son is acting as the go-between them here. And it became really, really obvious because the guy representing the bank put this in his affidavit. So it was they couldn't really turn around and argue anything else. The bank, he must have not have been a very good employee. So he put in his affidavit that he was there, and the son was going backwards and forwards between him signing the documents and getting the parents to come over and read it. And it became abundantly clear that the parents' knowledge of English was very, very poor, and abundantly clear that they probably didn't really know what was happening here. And they certainly wouldn't have known that this was a guarantee for the house. And so in guaranteeing a particular loan, that is where you promise to, in this situation, to repay a loan debt when it goes sour. And the way you repay, if you're elderly Italian migrants, is with your own house. And again, you can see where this is going. The son's business went belly up. The bank wanted the money back, so they went to sell the Amadio's house. Went all the way to the High Court, and the High Court said no. And it said no because it says that equity, the area of law known as equity, doesn't allow certain types of injustices to happen. And it said it's phrased in a variety of different ways, and importantly for our consideration, it's phrased differently to what it is for undue influence. Undue influence is about a relationship of trust and confidence. Unconscionable transactions or unconscionable dealings is about a special disadvantage that the other side knows about and actively seeks to exploit. I'll say that again. So equity can intervene to vitiate a contract where one party to the contract knows the other side have what we call a special disadvantage. They become aware of it and they actively seek to exploit this special disadvantage. And we say that that's done in bad conscience. Okay, and in this situation with the Amadios, the High Court said that the bank, again, the officer of the bank, was on behalf of the bank, knew the Amadios' English was not very good, knew that they didn't understand the nature of what was actually happening here. They knew that the son was going to have an overwhelming amount of say because he was acting as the translation here. This is a special disadvantage. All right, they knew about it and they didn't care. They just went, they knew about this advantage and used it to fulfill their requirement, which was to get the loan in that particular case. Okay, so that is how the doctrine we call of unconscionable transactions is framed. That phrase is like spot on. We get that from case. Okay, good. We've got some more cases. Now, what is a special disadvantage? This is not an exhaustive list. What does that mean? It means that here's a list of things that the courts have found are special disadvantages or can be special disadvantages, but there are more. There can be many more. Okay, and I'll talk about Blomley and Ryan. Blomley and Ryan was a case, it was before Amadio's case, and it involved, it's very Australian, it involved agriculture and binge drinking. So Ryan, I think Ryan was the farmer. Actually, you find with a lot of these cases, I don't actually remember which of the two names. The names get mixed up in my head in terms of who was the plaintiff and who was the applicant, because when things go on appeal, the names get switched around. So you often forget about this. But I was an old guy. He was a farmer. All right. And he he had a big farm and he had a nephew. Sorry, not a nephew. No, different situation. No. Ryan's the old guy. Okay, thanks, Katana. Cheers. I think I might have. Did I teach you this back in 2013? Might have. So Ryan's the old guy, and so he is an old guy, has a farm, and the neighbours have been wanting to buy the farm for ages. All right, they've been wanting to go to the farm, and so one day they rock up to his house and say, and this is important, they rock up to his house with, has anyone read you probably haven't read the case, rocks up with 2 bottles of rum, knowing the old guy is a long-standing, tragic alcoholic. I rock up to the house, 2 bottles of rum, get drunk, and then ask him if he wants to sell the house. And eventually he's like, you guys have been asking me for years. Okay, here we go. All right? And so again, this went all the way to the High Court, and the High Court said that, look, there in that situation, you guys knew about the guy's particular or peculiar special disadvantage. And in that situation, you knew also that disadvantage, if you exploited it, that would undermine his ability to make a self-interested decision. You knew that he was an alcoholic. If you went there with booze, got him drunk, he was much more likely to sign the house over for you guys, the land over for a good rate. The court said there, that is a special disadvantage. Okay. Similarly, although kind of funnily, Louth and Diprose is from, the facts happened in the 80s, but the case went to the High Court in the 90s. Louth and Diprose involved a pretty hopeless guy. He was really into this woman. And it was really clear from the facts, she wasn't really into him. She already had kids from previous relationship. And he would just shower her with gifts and give her and buy her things. He was really into her. She wasn't really into him, but hey, she's happy to have the gifts, right? So, and so what she realized is that, if I, the guy will come around and he's more likely to give me money if I, say, oh no, I'm really short of money this week, and oh no, the kid's father is going to have to come over to this, and oh, my car's broken down. if these situations of crises come up, the guy's more likely to sort of, shower with gifts, give him money, and what have you. Anyway, eventually, he thought that they'd been together for some length of time. How about we buy a place and I'll put it in your name. So buy a contract, put it in your name, and and so that's what we'll do. We'll go through and do that. And you can just you can live in it, and I'll come and stay and so on. So anyway, so he goes and buys her a house. All right, and guess what happens? Guess what happens after he's bought her a house? You can imagine. I've actually seen this happen in practice too. So after he's got the house, she's like, "Woohoo! I got a house," and so she just doesn't want to talk to him anymore. Didn't see that one coming. And so there, the High Court said that, look, in this situation, his infatuation with her, all right, and his blind, almost obsession with her was actually a a disadvantage. She knew about it, and she created these situations of crises to actively exploit it. In other words, to get this benefit from him. So that's what she did to be able to get him in this situation to go and buy a house for her. There, the court said infatuation in this situation was going to be a special disadvantage. Now, no surprises to find out that Mr. Louth, guess what? He was a lawyer. So lawyers, basically had reached this point, had given her a house, and then when he realized that he didn't want her, the penny drops that she's really not that into him, and so then he rocks up to the court and he won. He won. It's sort of like an anti-feminist case. Unbelievable. Yeah, I know. Some of these cases can be a bit like that. They get better. All right. So that's unconscionable things. And look, that statement that I had before about it being a special disadvantage, the other side knows about it, and actively exploits it in bad conscience. That's what unconscionable means within the meaning of the unwritten law. That phrase means something because when you read Section 20 of the Australian Consumer Law for your assignment, you'll go, that's what Simon's talking about. Those are the things you need to prove to satisfy that element in that section. Now, for both undue influence and unconscionable dealings, UI and UD, you can, as the person seeking to uphold the contract, actually go through and make an argument that this transaction was just, fair, and reasonable. Okay, so you can go through and do this. Now, remember I made the comment about the courts don't care about the fairness of contracts? All right, well, it turns out in equity they do. When you're using in court's equitable jurisdiction, if there's undue influence is proved or unconscionable dealings is proved, you, as the defendant, can still win, but you've got to prove this thing. You have to rock up to court and prove, on balance of probabilities, that the transaction was fair and reasonable. In other words, usually the amount that was paid was fair and reasonable, and that you strongly encourage them to seek independent legal advice. Okay? Now, again, the fairness of the transactions is objectively determined. In other words, it's a reasonable person. What would a reasonable person think a fair and reasonable amount is? What would a third party, a reasonable third party coming and looking in, think that this amount would be? All right, it's not what either of the parties think is fair and reasonable. That's the key takeaway there. And that's Taylor and Johnson, by the way. That's the case we had earlier for unilateral mistake. And in some situations, all right, you can go and take the person, and this is important for your assignment as well. You can only, in English, the expression is lead a horse to water. You can't make it drink. And so in Bridgewater and Lay, I think it was Bill Lay. I think Lay was the older guy here. He had a nephew. He had 4 daughters. All right, he lived on farms. All of these things are all about farms. 4 daughters and a nephew. The daughters all lived in the city. Didn't really want to see their old man very much. Didn't really care. They certainly weren't going to come work on the farm. But he had a nephew who did. The nephew worked with for a long time. The nephew was good. The nephew would rock up. The nephew was helpful. The nephew wanted to be there. And this guy made a call. Look, the nephew's the person who should get the farm because he's the one who has the connection to land. If the girls want to do it, they should come and do it. They can come and live on here. They don't want to do it. Therefore, I'm going to go and give it to him. Now, what happened is that they said, okay, cool, this sounds good, guys. This sounds okay. Let's do this, but we better get some lawyers in on it. So what they did is they went to a lawyer. They did go to a lawyer. The trouble is, they were in a small town, and so they went to his lawyer. And when the 4 daughters, the old man died, and the 4 daughters then came along and said, "Oh, we'd like the farm, please." And the daughters won. Why? It actually hinged on that fact. The fact that the legal advice wasn't independent. So they'd gone to a lawyer. There was only one lawyer in town. Didn't matter. You had to go further afield in order to do that. For you to demonstrate, you've got to put all your cards on the table. You've got to demonstrate that it's fair and reasonable. You've got to demonstrate that you've strongly encouraged them to get third-party independent legal advice in order to rebut these things. And if they, again, in that situation, the same lawyer, it's not going to work. And Bridgewater and Lay is the case where they said that. Might want to remember that for your assessment. Hina.
As per my understanding, if I am handing over my farm to someone, it's my right to give it to anyone I want. How can the kids reverse the decision?
Where is this legal rule or principle that you make this assertion that it is your right to give it to anyone you want? Yeah, no, you don't have to do that, Ken. He can talk. It's fine. It's actually not that clear cut because remember.
I don't feel like breaking you in the middle.
No, that's fine. It seems weird.
What a layman have an understanding is that if I want something, it's mine and I can give it to anyone I want.
Oh, I agree. And this is a good example.
Am I wrong?
Not well. Again, there is what was it? Exceptions to that broad rule. You are right. The starting point. It is a key indicia of property. All right. Yorta yorta is the case. We'll talk about that. One of the key indicias of property is the right to give it away to whoever I want. All right. That is a fundamental principle or rule that we do have in our legal system. So that's fine. You are right as a starting point. But this particular area of law to do with vitiating factors is when contracts are made. All right, contracts are made. Now, contracts and gifts, when you're talking about undue influence and unconscionable transactions, the rules for overturning those things, where there is some form of defect of the mind, all right, is actually the same for both. It's not for mistake and it's not for misrepresentation because they involve actual contracts. Unconscionable dealings and undue influence can actually occur when things are gifts as well. I'm talking here for the subject in the context of contracts, but the same rules apply for gifts. If you go and give your thing away, you can give it to whoever you like. But assuming that you then die, so sorry, Hina, sorry to say this, and it's your children, your children are then, not long afterwards, are then trying to have this transaction set aside. It's not usually the person who's given the thing away because they wanted to give it away. Of course they did. That was what they think they're in a free mind. But what we accept is that people's will gets overborne, right? And if the will is overborne in this unfair way, if I think one of the earlier, the Hare Krishna, the Hare Krishna is my best friend is she's Hindu and she describes me Hare Krishna, which is what do they call it? It's Hinduism for dumb white people. This long-standing, getting this voice in the ear of, hey, to be a good person doing this, you should, give away your material things. To be good in doing this, you should give away your material things, and eventually you give into that and give it away. That can be, even if it's a gift or a contract, subject to these clauses. You're not really, and this is where the law comes from, you're not really thinking straight. Your will is overborne. The guy in Louth and Diprose, the case earlier, who had the infatuation with the woman, not thinking straight. The guy who was the alcoholic, not thinking straight. This is really...
In the previous cases, like the old lady who was being looked after, she gave her home, that is understandable. But in this case, her daughter was not even bothered to work in the farm.
I know. I know. It doesn't look fair, does it? Well, yeah, this is the tricky thing is there's one word that I hope if you guys get from my course or any courses I ever teach. I did a philosophy degree, amongst others. If there's one word that I want you to reconsider in your life, it is the word deserve. step back, think about that word, because again, I've studied this for a long time, distributive justice and a variety of other things. That word is so loaded and it's filled with all sorts of preconceived notions, because the whole point of law, this area of law, and particularly I taught trust last semester as well, so the trust law is that both sides think they deserve it. So we can't use desert as a mechanism for allocating things in law. We have to set it aside. We just have to set it aside. We have to use principles, and the principle that we use in Australian law in this area known as equity is unconscionability. This idea of something being in bad conscience for somebody to get the advantage. It's not about deserve, and it's not about people being unjustly enriched. Those two things doesn't really form the language. So that phrase that I had earlier from Amadio's case, special disadvantage, knowing about it, actively exploiting it. That is how the law works here, because we've tried all sorts of these other ways and it doesn't work, because what I think I deserve and what you think you deserve and what they over there think they deserve is always going to be different. That's why we have law. Okay. Illegality. All right, so those defenses, by the way, they're super important, because they're the defenses are things you must talk about in your assessment, because they form part of that definition of unconscionable. They're one and the same. They form part of it. I'll explain that more in a bit more depth later. All right, illegality. We're going to probably be short on time with this, and there's quite a few slides too, so I'm not going to labour the point. Some things you need to know. Look, illegality is where sometimes it's looked at as a vitiating factor, sometimes it's an element of contract. The key thing to note is that strictly unlawful contracts, if Michelle puts out a contract to have me, what you guys are having a hard time with your assessment, so Michelle puts out a contract to pay Elma $100,000 for having me knocked off. All right, are the courts going to enforce that? Contract to kill? Do you think they're going to enforce that? No, you're going to go to jail. That's what happened in a case that probably got it further down, called Everett and Williams, where two highwaymen decided that they robbed all these carriages, killed a bunch of people, and then decided that to resolve their dispute as to who got what, they'd go to court. And so they went to court and then both got hanged, and the lawyer went to jail because that was dumb. Probably never happened, probably an urban myth. Anyway, so this idea of this ex turpi causa, that's the idea that illegal contracts will not be enforceable. It's not that they're not that we're going to do anything else. We're not going to send you to jail or anything. We're just not going to do anything about it. Okay? And this, you can have situations where a contract looks lawful as formed, but there can be some way that either a statute or the common law, which is these public policy grounds, will actually render it unlawful. In other words, unenforceable in the courts. I'm going to quickly run through these. All right, and so this forms these two branches. We have the first one is what we call statutory illegality. That is where Parliament has come along and said some contracts you can't have. For example, during the war, First World War, you can't have contracts with the Germans. Pretty straightforward. No contracts with the Germans, shall we say. Now, the difficulty is that's fine. You know, you can't have contracts to pay somebody less than the award wage. Sure, that's pretty straightforward. All right, that's a pretty easy one. However, you can have other forms of contracts that are impliedly prohibited. So, for example, sure, so Hina's got a contract with me, and she wants to pay me as little as possible. Sorry, Hina. And for me to come and clean her house or what have you. So instead of paying me as an employee, she says, I'm just going to pay you $50 for the whole job. The job should take you to 5 hours to do, for example. And so this, in some situations, the Fair Work Act is in place, there's a statutes in place, and creating this agreement to try and bypass it is going to be impliedly prohibited as well. You're just trying to bypass the statute, the minimum wage legislation in that case. All right. The courts don't like finding things impliedly done when you're trying to read the purpose of the statute and trying to work things out. They like trying to read the statute and try and work out and determine whether or not this particular statute was actually set out to protect particular people. So first, It's an example. Yanko Pastoral and First Chicago is a banking case. It involved the Banking Act, where an American bank, First Chicago Bank, was operating in Australia without a license. And so what happened? A whole bunch of people who took loans with the bank, all right, were like, oh, they don't have a license. Therefore, our contract's unlawful. Therefore, we don't have to repay it. And the court said, no. That's not how this works. The purpose of the banking license, that legislation is to regulate banking, to stop the banks from doing bad things to consumers. All right, you lot are a big, pastoral entity, big entity. You're just trying to get out of your obligations here. These things, they're not related. This is designed to protect consumers, and the regulation, the fact that that's unlawful isn't going to get you out of your contractual obligations. Your contract is, strictly speaking, is going to be legal as formed, so you're not going to get out of it. Okay. Just for reasons of time, there's a couple of things here. I will quickly talk about them. So statutory illegality, you must go through. When looking at these, there are 4 different ways that a statute can render a contract unlawful. Either that it expressly says you can't have a contract to do this. Hannah can't have a contract to pay me $10 an hour. She's got to pay me $16 or whatever the award weight is. All right. Or if the contract that we've got here can be of a type of class the statute expressly or impliedly prohibits. Contracts that are, in this case, sham contracting. So if instead of it being expressly prohibited, Hannah came to me and said, oh, why don't you get an ABN, a business number, and just come and exclusively clean my house. That's all you do as a job. All right. So that the class of persons, the Fair Work Act is designed to protect poor employees with no power by putting in minimum wages and so on. So that contract to try and have what we call a sham contract arrangement can be prohibited under the statute because it's of a type or class that the statute doesn't either expressly or impliedly prohibits. Okay, a contract can be made to effect an unlawful purpose. In other words, if I had this contract to clean, but the unlawful purpose was that you were getting me to go and you were paying me to break a contract that I had with somebody else. All right, so I'm going to pay you to go and breach a contract. Strictly speaking, paying somebody to breach a contract is actually, strictly speaking, an unlawful purpose. That can be one way to go through and do that. Or if Hina was paying me to clean these things, but she insisted that I had to use the sort of chemicals you're only allowed to get, cleaning chemicals you can only buy with a license. Okay, so I'm going to have to clean the house with this super stuff, but essentially the purpose we're doing it is unlawful, or performed in a forbidden manner. In other words, I don't know, beating me for when I'm not performing my tasks while doing it. Okay, legal is performed if one of both parties intended that will be performed. All right, so that which one? Nathan, can't hear? Yeah, sorry. I'm going to turn my video off here. I'm talking quite relatively quickly as well. All right, and so just note, St. John's Shipping and Joseph Rank, that was a case involving what we call incidental illegality. Do you guys know what the plimsoll line is? Anybody heard of that? Plimsoll line, it's a thing on boats, a little measure to determine whether or not boats were overloaded. It was this real problem that you have in the olden days where boats would get overloaded and then they'd sink and then somebody would claim insurance. So Mr. Plimsoll came along and said, this is these lines that says how much this boat can have. And anyway, these St. John Shipping and Joseph Rank involved a massive shipment of goods across the Atlantic, and the price of the goods fell dramatically. So the purchaser didn't want to be in this contract anymore. When the boats rocked up, they looked at the plimsoll line and said, you're over the limit. Therefore, this contract's illegal because you're over the limit. That's unlawful. Therefore, this is not a valid contract. Therefore, we don't want to pay. And the court said, no. This is what's called incidental illegality. It isn't going to render the contract void as a result, or unenforceable as a result. Okay, 7 minutes. As well as there being contracts that are invalid or rendered unlawful or illegal under statute, you can also have what's called common law illegality. So it turns out if George, Hina, Emmanuel, Carmel, and me, if we decide to go and play a game of poker, and George wins, and we just go, oh no, we don't want to pay. Turns out we don't have to pay. Do you want to know why? Because contracts or agreements to gamble are not enforceable in the courts. They are against public policy, and as a result, are not enforceable in the courts. So there you go. It's more a piece of trivia than anything else. But certain types of contracts, the courts, even though they're not strictly illegal, you're not going to go to jail for doing that, but the courts won't enforce it. So the only way the casino gets to operate, by the way, is Parliament says so. They map it out in statute. Okay. Common law contracts for crimes, committing crimes towards or frauds of third parties, they're going to be illegal. They won't be enforced. That's Everett and Williams. Interestingly, contracts promoting, and I love this, sexual immorality or contracts that are prejudicial to the status of marriage. There you go. They're actually unlawful at common law. So contracts for if you get into a contract to try and break up someone's marriage, it will not be enforced by the court. There you go. You guys learned something today, if only one thing. Contracts to defraud the revenue. It might be in the later slide. Are not going to be, in other words, to rip off the tax office. They're not going to be lawful common law. Contracts to conceal offences, compromise prosecutions, impede justice. In other words, undermine justice. Bribing a contract to bribe a police officer is going to be invalid at common law as well. And oddly, things that damage Australia's reputation can be held unlawful. Okay. These things are little, kind of corner cases. The key thing that you need to know, the really important one, isn't on this slide. It's on the next slide. And that is a type of contract called a restraint of trade clause. Okay? Restraint of trade clauses are a special type of clause. Oh, boo, that was my next one as well. Prejudices. Oh, that was the foreign country one as well. Okay. All right, restraint of trade clause is a special type of contractual clause where you pay some money, in other words, or offer some consideration for another person to not work in a particular industry and for a particular length of time and for a particular geographical space. Okay, so you can pay somebody to not, in this case, Buckley and Tutty you can pay somebody to not play football in any other competition in New South Wales for a period of 5 years. So football, New South Wales, 5 years. Okay, this is how restraint of trade clauses work. Right now, strictly speaking, they are going to be reasonable restraint of trade clauses that go no further than protecting the interests of the parties. The courts will uphold them, but they construe them quite tightly. All right, and they look at a lot of things. For example, this last one, they look at the industry. They look at how much poverty it's going to cause on an individual. So that Warner Brothers and Nelson was a case involving a movie star called Betty Davis, who signed a contract that said she wouldn't work for another movie company for the next 5 years. And she went to England, worked for another movie company. She got sued, and the court said, no, actually, we will uphold this. We will grant the injunction because she's not going to starve. Whereas if you or I entered into a contract, the courts are going to look at how reasonable it is. So for me, for example, if I entered into a contract that said I will not work for any other university doing any form of teaching or any form of research or any form of software development for a period of 10 years, all right, is that reasonable? Well, it depends. What's the one thing that it depends on? That would be the one very, very important. How much are they paying you? Exactly. It's how much money it is. Because if that was $10 million, I'm in. If it was $10,000, I'm not in. So that's what the courts look at. They actually look at the amount, which is good. Thanks, Federico. They look at the amount, and then they look at how reasonable it is. And so often, if you guys may be involved in drafting these things, restraint of trade clauses, often people will put in a series of clauses. So, for example, Simon, after working, cannot work at any university in Australia for 5 years. And then the next one will be, assuming that doesn't work, Simon is restrained from working at any university in Queensland for 3 years. And there'll be another one. Simon is not allowed to work for CQU for 1 year or something like that. So they put a series of these things in because the courts go through and they try and work out, is the first one reasonable? No. Is the second one reasonable? No. Is the third one reasonable? Yes. Okay, that one can stay in. The rest of them go. That's how these things are drafted traditionally. And you have to look at the industry. So this Nordenfeld and Maxim Nordenfeld guns was a restraint of trade clause, but I think it was for 25 years. It involved an arms dealers. Arms dealers, there aren't very many. There aren't very many arms dealers in the world. So as a result, the courts were actually said, look, in this situation, not selling guns for 25 years in a certain industry, that's fine. That's fine, even though it seems really, really big. So the industry matters. Okay, next one, there's some more clauses. These are particular clauses, and these are important, especially the last one, what's called a Scott and Avery clause. Even though I'm just mentioning it really, really briefly, it's super, 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 super important. We call these now Scott and Avery clauses. You can put in a contract a clause that says we must go to arbitration, and this is where we're going to go before we go to court, and the courts will actually uphold that. You can't, however, put a clause in a contract that says if you don't like it, you can't go to court until 5 years has passed or something similar, until something else has happened. Courts won't ever uphold that. You can't oust the jurisdiction of the courts. Restraint of trade clauses where you have what's called exclusive dealing. A lot of these cases involve petrol stations and oil companies where they say you will only sell our petrol. And what they say is that, look, exclusive dealing, the courts don't like it and they construe them very narrowly. They have to be reasonable. You can't completely exclude people, and the amounts, again, going back to as Rico raised the point, the amounts that you're paying people to only deal with you have to be worth it to them. And the ACCC actually has specific powers to go through and authorize particular things. So if you are trying, and you guys are setting up a contract for exclusive dealing, exclusive dealing, by the way, is having usually one of your customers who on-sells your product, having rules they have to follow to sell your products. One of them is that you only sell our products, not our competitors. All right, these contracts you can have, and you can ask the ACCC, the regulator, whether this contract is okay or not. So there's actually a mechanism for going through and asking them ahead of time before these things go before these things have to go off to court. All right, I'm going to talk about remedies. This bit's actually pretty important. I'm sorry I've left it till 9 o'clock. I'm going to zoom through these things now. All right, I'm not going to read the slide. Just make note, undue influence and unconscionable transactions. These are rules in equity, and the equitable maxims apply, whereas the others are all common law actions. Misrepresentation is a bit of an oddball. There's an argument you can do it in both. For the purposes of this course, we're considering it to be common law. Okay, I'll leave the rest of that. I'm not going to go through those. That's more sort of theory stuff. We'll start with misrepresentation, though. Misrepresentation, the right you get if you prove misrepresentation, all right, any misrepresentation, is the right to undo the contract, to rescind it. All right, and whether that's in equity or common law, the rules are kind of similar. All right, because the idea is that if a representation has been made to you, it's false, it's a statement of fact, it's addressed to you and intended to introduce you and actually did succeed in doing so, you can ask the contract to be undone, but you have to do it quickly. All right, and you can do that regardless of what type of misrepresentation. All right, and because there are three types. You can have innocent misrepresentation where it was an honest mistake. No one is at fault. You can have what's called negligent representation, which is where, in this case, going back to Tala and the document, the representation from Harvey Norman. If Harvey Norman was negligent, all right, they owe a duty to the people they give these things to. They fell below that standard. Harm has come as a result because Tala's gone to buy this computer. You can seek damages, what's called the tort of negligence. All right, and if you're fast enough, you can rescind the contract. In other words, undo it. If, however, they actually lied to you, so if they had actual knowledge, and you have to prove this, they actually the falsehood, the false statement, they knew that it was false or were recklessly indifference. You can claim damages in this cause of action known as the tort of deceit. You can also rescind the contract as well. In other words, undo the contract if you can. And the courts are much happier to do that at common law. Again, if you can go prove that, yeah, I'll come back to that. Now, the key thing to note here, if somebody's lied to you, right, and the amount that you can get, you have to prove the harm that you've caused, but the harm doesn't have to be foreseeable. It doesn't have to be reasonably foreseeable. There's a difference between the tort of deceit and the tort of negligence. We'll talk about these things when we do tort later on. So just make note, with misrepresentation, the three types: negligent, fraudulent, and innocent. Innocent misrepresentation, you don't get damages. You only get the right to undo the contract. You don't get any money. And if you don't get onto it fast enough, you don't get anything. It's too bad. Okay, so there's a couple of things to note there. The tort stuff we're going to get to a bit later in the subject. Okay, you just need to know that these things, misrepresentation has different remedies depending on how the particular statements come to you. All right, the remedy for mistake is that a contract is void. It never existed. So mutual mistake and common mistake, there was no contract. The rules I was talking to you before about Solly and Butcher was that old things, and arguably in Queensland that doesn't apply because the Australia Estates case here is a Queensland case, and they said that this old rule of Solly and Butcher, you're not going to get a remedy probably now. I would think other courts would probably follow that. You're not going to get a mistake in you aren't going to get a remedy in equity where the mistake's not fundamental, even if there's an injustice. Doesn't matter. The rule in Taylor and Johnson, again, you get the right to rescind. You do not get damages. You don't get a money award. You get the right to undo the contract. So there, Mrs. Johnson, I think it was in that case, got the right, because she was fast enough, to undo that contract where the guy had, remember, she was mistaken, he knew about it and made sure she didn't find out. So that she had the right to rescind that. Okay, and you can get rectification equity. You don't have to worry about that. I don't assess that at all. All right, duress is a common law action. You can get, the idea of this is that you can rescind a common law to put people back to where they could be. If you can't do that, then you can get damaged, I think, for duress as well. I didn't put that in the slide for whatever reason. I'm not quite sure how that came about, but to rescind a common law, things have to be able to go back. All right, this is the important one, though. The important one here are the remedies you get for these actions. Now, importantly, when you see this on the slide, this is the remedies you get if you rock up to court to plead undue influence or unconscionable dealings. For your assignment, that stat interpretation question, you are not to plead those things. You are to plead a cause of action in and under the Australian consumer law. So you have to prove that there is undue influence and or unconscionable transactions. All right, you've got to go through and see whether or not those things can be proved, but you don't have to worry about these things. These things won't apply because you use the remedies from the Australian consumer law. So if you had brought a general law action, you would give the and you win, you get the right to rescind. If you do it fast enough, you can't take too long. This delay, and unclean transaction hands means that if you are trying to how do I say this nicely? They're trying to do something bad to you, but you're also trying to do something bad to them. The courts say in that situation, it's not there's no issue with conscience, so you can't claim an equity. It's this old phrase that you can't seek a remedy in equity for unclean hands. Okay, all right. The next slide I've got there is remedies for illegality. Usually you can't get your money back. That's how things work with illegality. I don't assess any of this. I don't go into this level of detail. It's more for your knowledge. Look, some of these areas of law have actually had quite a lot of judicial. I'll get my little pointer. A bunch of judicial discussion about them as to whether they apply or not. That one probably doesn't even apply. In Australia, it's a little bit contentious. Just the key thing to note, really, is the one at the top. Contracts that are illegal as formed. And you can try and use other areas of law to get these things back, but not if the contract is strictly unlawful. I'm not going to go. I don't think I'm going to do too much of these guys here. I think remedies for illegality, you can. Yeah, I'm not going to go into these. All right. I will briefly talk about this. All right, just really, really, really briefly. The very, very last thing is that where contracts are void, so this is not to do with illegality, this is where contracts can be void, and they can be void through mistake, they can be void through duress. You get the right to void a contract. I made the point here about the clause requiring arbitration. In fact, no, this is just repeating the previous one. No, don't worry about this slide. No, don't worry about this slide. So I can go. That slide's in by mistake. We finish here. That's good because I can't put it in the other one. All right, I'm going to leave it there because we're way over. Oh no, not way over time. All right, I have some questions. Does anybody have any questions about these things? Sorry guys, that last slide shouldn't be in there. It's a copy of an earlier one. I'll take it out. Hina, do you have any questions? Come on, you know you do.
We went a bit quicker. So,
Throw that one. Yeah, these are there. These ones are I don't assess these last two ones here. I don't assess. The reason being is that it's actually really complex. The rules for illegality can be quite difficult, and to be honest, the rules for illegality that are the important ones are things to do with things like restraint of trade clauses. And I think, I'm not too sure whether or not on that final slide I talked about no, I haven't got it in there. There's just one thing to note, that restraint of trade clauses, by definition have to carry on after the contract finishes. Okay, so I'll just say that again. If you have a restraint of trade clause that says, all right, I'm going to employ you, so Hina, I'm going to employ you to be a software developer here, and I'm going to put in the contract that says after you finish working for me, you can't work as a software developer in North Queensland for a period of 3 years. Okay? Assuming that restraint of clause is valid, when our contract comes to an end, the restraint of trade clause actually has to carry on by definition. It has to carry on after performance from both sides is finished. I've stopped paying you, you've stopped turning up to work, we've gone our separate ways. But the restraint of trade clause endures afterwards. So just make note of that one. That's really the key thing that to take away from that. That restraint of trade clauses can work, but you have to be a little bit careful with them. Really, that's the key thing for you guys to note here. All right. Do we have any other questions other than that, guys? Because there's a lot of material for that last one. We don't have to worry about this.
is our quiz still this lecture or the next lecture?
The next lecture as well.
But the questions that you told us that day on the YouTube,
Yep.
the questions are already done now.
What do you mean? Sorry, I'm confused.
Like on the YouTube, you gave us 20 questions that you said we're going to have questions from these topics. We have covered all of those topics in today's lecture.
Yeah.
Are you changing the test now?
No. The test always
The quiz.
both the quiz, the practice test, as well as the quiz there, is to the end of week 6. That's definitely what it is.
But the questions that you put on the YouTube, they are covered in today's lecture till here. Like whatever is we're going to study with the next week is not in that list in the quiz. So are you going to change the questions now?
So I mean to say the questions that we there was a couple of questions in week 1. I think you wanted me to change to take out. No, I'm really confused, Hina. Sorry, I'm not following.
There was a video on YouTube that
Yep.
explained the quiz.
Oh, okay.
And you said this question will come from this topic and this question will come from this topic.
Sure.
And all of the topics from start till end are covered in today's lecture from start till now. The next lecture that we're going to have,
Yep.
those topics are not there in the quiz.
No, they definitely are. They definitely are. It's to do with, it'll be there. It's damages, the discharge by performance, discharge through frustration, discharge through breach and repudiation, anticipatory breach, and remedies in common law. So it'll be damages, the rules for limiting damages, the rules for causation, mitigation, remoteness, and the rules for the non-damage remedies. So injunctions and specific performance. Those are definitely in there. Definitely.
Okay. The question you just mentioned, remedies. So in remedies,
Yeah. So it's everything from weeks 1 through 6. So this is week 5 that we've just done now, and everything up until till next week. So you got to appreciate. I would recommend going through and having a watch of the YouTube. Well, first of all, piece of strategic advice: sit down for an hour, do the practice test. I would probably do it twice if I were you. I'd probably do it once and then go, oh wow, that was hard. And then once you've gone through the material a little bit earlier, go through and do it again. I would recommend to go through and do that.
I don't know about others, but for me it's hard. I don't know how everyone is so relaxed.
Are they really?
They seem
Seem very relaxed. We get relaxed. The next week takes about 6 hours. So the test, which is next week on the Friday, includes the material from next week. Definitely not relaxed. I mean, it's
tell him we are not relaxed. Please
okay.
give us an easy exam.
An easy exam. I will. I'm definitely going to give you. The one thing that I am definitely promised you is that the take home. Well, I actually think that the assignment that you guys have got is a little bit challenging. I think for you guys to go through the stat interpretation part, because you are going to have to go through and do stat interpretation to do it, and if you do go through and have a have a look at the Australian consumer law stuff, because that's a few weeks away before we go through the material. The one thing that I do have is that I would recommend for next week's lecture that you watch the screencast ahead of time. So if you can, do the test and watch the screencast. So the screencast that I did 2 years ago for it.
Simon, my point is
Mm.
when I solved that question that I've sent in the email,
Yep.
I had a different understanding of solving.
Yep.
When you gave me the answers,
Yep.
now I know how to solve it.
Good.
The point is, same goes for the assignment.
Yep.
We might end up going a different way and
Yes.
expecting something different.
Nope.
Any source, any sample, like you might do this from years.
Yeah, I can. What I can do, I can probably find you a good sample, but not for those sections. I'll find you an example of one from different sections in the Australian consumer law. Okay, that's fine. I can definitely do that. Yep. Yep. No, that's fine. I'll go and find I'll go find an assignment that's been done. That seems good. I'll go see if I can find one. Yeah, I can do that. In fact, I'll see if I can find it right now, literally while we speak. And let's have a little look. Oh no, maybe not on this. Maybe not on this computer. It's possible. It might be on my other computer. I think it is. All right. I will not be doing it right now. But I will go through over the next, probably over the weekend, and I'll find. When will I know exactly what is the assignment? I've released the assignment. So the task is there. It's a stat interpretation task, and it's basically advise the client. To do that, you have to go through and follow the rules in the Australian consumer law, which we haven't done yet. So when we do the Australian consumer law, and I go particularly over sections 20 and 21, you might find that particular lecture really, really helpful. And again, there's screencasts that I've done from 2 years ago, which you can go through and do that in advance if you want to. So you can probably get started on it now if you want to go through and look at that material ahead of time. But note, the key takeaway from that was the discussion board. You do have to participate in the discussion board. That's something that, and you have to do that before the 1st of May. Okay, so just bear that in mind. Yep, the discussion boards. Oh no, is this moment where it's like, what's a discussion board? If you go into Learn JCU and you go into learning activity, and you go into any of the topics, so topic 3, contract formation, discussion board. So you go into those things and you just write whatever comes to your mind. And so the idea is that I will check that, and I will check it programmatically to see whether people have gone through and made 6 contributions spread across at least 2 topics. They have to be a reasonable contribution. So just saying, I don't understand, not a reasonable contribution. You don't have to be right, but you have to give it a good go. You have to give it, and you have to give it a good go based on the material that you guys have learned, not stuff off the top of your head. I don't think this is good law because my sister makes candles and doesn't, I don't know, some reason. Oh, because they deserve it. I don't want to see the word deserve it anywhere. Sorry.
Now you're using the word value.
Yeah, don't want to see the word deserve. Don't use that word. Not the dreaded D word. And so just make note, by the way, guys, the slides on the screen here, this won't come up in your assignment because you're not using the remedies under the general law. We're going to be using remedies in the Australian consumer law. So that stuff won't come up. So this rescission and delay and the uncleans rule, we're not going to worry about that. That's not going to apply as part and parcel of things. So just you don't have to worry about that. Yeah, that's pretty much with that. I'm going to stop sharing the screen. You can share each other things. Just one thing, I do not understand where I can give your contribution. What do you mean? Contribution? What? Oh, hang on. Oh, to hand in your assignment or contribution to the law lecturer's drinking fund? Because that doesn't sound like a bribe at all. Okay, so to hand in your assessment, we give you a contribution. So to hand in the assessment, it's in the same place where you download it. There's a little box. So if we go into the assessment folder, there'll be an assignment tab, and it'll have an availability based on date. So it's due on the 15th of the 5th. And so you just go into there, and you can I think you just click submit on the bottom, and you can add whatever you've got to it. To watch this lecture recording again, you go into the subject site, and just to the right of where it has subject room, there are 3 dots called these ellipses. And if you click on those 3 dots, there's a little drop down, and one of those drop downs is to view all recordings. This one's very long, so it's not going to come up for another at least an hour or so. So it'll be there by tomorrow. It's just the software takes a little while, and because I dropped out at some stage, I don't know how that's going to work with me dropping out. Oh no, it'll carry on because the recording carried on. You guys will stay in the room. The recording will carry on.
Simon, if we don't understand the
Yep.
assignment, if we think we are doing it the wrong way,
Yep.
can we send you how much work we have done to get an idea?
Yeah, you can. There's some caveats on that. I used to have what's called a structured feed forward thing. So I'd say, look, I'll take a full draft. If you've done a full draft and you've done it 10 days out from when the topic is due. So what's for this, guys? When's this thing due? It's due, what did I say? It was the 15th? It's due on the 15th of May. If you have a full draft to me 10 days out, and that has to be a full draft, not half done, I want it to a genuine, solid, good go, I will have a 3-day turnaround to give you structured feedback and get that back to you. Okay? Now, I said this is a master's level subject, so if everyone is struggling, I wholeheartedly recommend that you guys take that up, by the way. I'll spend 3 days, I'll do it full time if I need to, it doesn't matter, to give you guys feedback, because I want you guys to do very well in this. I want hand on heart to go back to the accounting society, to the AQF guys, and do all these things and say, hey, look, here are our master students, they're doing a really good job. Here we go. So these things are not designed to trap. They're not at all designed to trap you guys at all. And so the way the test is designed, look, when I say test is designed, it's a formative test. The lecture slides, using the lecture slides, getting the rules from them, taking them in. You can literally, if you're familiar with them, you know where to go, you usually can just go, oh, that rule, that case, this rule, that case. You'll find that the way that the test is structured, usually there'll be 4 or 5 statements. It'll be like, which of the following are true? And there'll be 4 or 5 statements, and some of them will be true, some of them will be rubbish. Just rubbish I've made up. And so you have to work out which ones are true, which ones are rubbish. And again, a lot of those things, they flow back from the slides themselves in terms of the underlying law. And if you get a little bit stuck, one of the advantages of doing those things is sometimes you'll be like, well, I know this one's definitely true. I know that one's definitely true. I don't know what these other 3 things are. Go and look at the answers. If there's only one answer that says A and E are true, you're winning. So it's kind of like an easier way of doing those things. Be a little bit wise when you're doing that test. But no, if you're doing that, it uses up time. And so you want to have good knowledge of questions that you know really well to be able to go through it quickly. Doof, 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 doof. Because I think is it 45 minutes, that test? I think plus or minus. I'm not sure. I think it's 45. It's 20 questions in 45 minutes. So you can't dawdle. You've got to go pretty quickly. And like I said, particularly the having to translate stuff is hard. Okay, and yes. Oh, Enrico, sorry. Did I not? I didn't answer your question, did I? Sorry. Where you can give. I didn't really understand what you meant by contribution. That's all.
Can you hear me?
I can hear you. Yeah, definitely hear you. I didn't understand what you meant by contribution.
When we go in the page, in the business law page, we have start here, assessment,
Oh, to test the plagiarism, like to do no, no. I'm
Everyone, like every one of you has to give the contribution of the
Oh, by that. Oh, I didn't even. To be honest, I was just expecting just to email, but actually, when you say that, it is way better. I'll just put that in now. That's a brilliant idea. I just because the previous years I've been doing by email.
What did you do?
Brilliant, brilliant man. Oh, that's great. So I'll have a little
He was just
Dropbox.
joking. He was just joking. Don't take him
Oh
seriously.
no, that's a great idea. Feed forward. I did a feed forward Dropbox. That's a great idea. Oh, well done.
but everyone can see the answer of the other. You
Yeah.
can share things like that.
Yeah, those things there, and I can put a due date in. That's really good. So I'm just putting a Dropbox in for you guys to submit a draft before I think we'll say the 5th of May. So I'll just put that in like a okay, that seems fair. Thank you. That saved me a lot of time. I appreciate that. That's awesome. Okay, so go, oh, something went wrong. Okay, well, it's not liking me. Oh, it's just kicked me out. I'll set that up. It's on my to-do list. Oh, no, there we go. Now it's in there now. Okay, I'm not going to sit here on the recording and go through and do that, but I will take any more questions if anyone's there. But the session's essentially over, guys. I don't want to keep you guys up. It's like 9:30 at night. Can we think of anything else? Any other sort of questions and stuff? But look, it's just for us, there's a case of getting used to the technology too. It's going to take a little bit of time. Don't know what happened with my computer. It just didn't like it. It just died. Not sure. I really don't know what happened there. That doesn't bode well. I've got my desktop. I brought it home as well. Maybe it's, yeah, not sure. Possibly I had too many things open and Chrome just decided, oh, had too much memory. Not sure. Right, I'm going to stop the streaming. So